is David Little, and my colleague here is Christopher Warren. And we are the reporters whom ministers have appointed to conduct the public inquiry and to report to them with our recommendations on whether or not the application should be granted. And of course, we met many of you last week at some of the community hearing sessions. Can I just check, can everyone hear me okay at the back of the hall? Okay, thank you. So I'll go around the table shortly and ask people to introduce themselves. All of those who are taking part today should already have submitted their hearing statement and any written evidence that they wish to submit. So we're not expecting to hear today from anyone who's not submitted a hearing statement. And I'll just go through a few housekeeping points first. So today's meeting hopefully is being webcast live on our YouTube channel. More about that in a second. And that's been managed by our colleague Craig Simpson. It's also been recorded and retained so it can be watched on demand. It will be retained by us and may be used for purposes including training and for providing information to members of the public. And the cameras will be mostly focused on those participating, but in accordance with our privacy notice, you are, by attending or participating, agreeing to the filming, hearing and the use of that recording for those purposes. I've already given some people the Wi-Fi password. We're using the Wi-Fi, hopefully, to stream this, but the signal strength might not stand up. So for anyone who's watching, apologies if our signal goes off. We are recording the session, so if there are any breaks, we will upload the full recorded version of it when we get a chance. But can I ask anyone who's using the Wi-Fi today, when you're not actually using it, if you could please disconnect from it, so that might just help us with getting the signal out to everyone. So what else? Fire escapes are located to my left, and there's one behind me to the right. Don't think there's anyone on the first floor today. Toilets, there is a gents' toilet on the ground floor. There's a ladies' halfway up the landing, halfway up the staircase on the landing as you come up. And there's an accessible toilet through that door over to the far left corner as well. I'll explain a little more about how the day will run in a minute, but first let's go around the table and everyone can introduce themselves. So first for the applicant, Mr. Burnett, please.
Thank you, sir. I'm Alice Burnett, King's Counsel. I'm instructed, along with my colleague Graham Middleton, by Geraint Hughes of SSE, and it's probably easiest if I ask the people on the front table to introduce themselves.
Good morning, everyone. I'm Callum Grant, Senior Development Project Manager for SSE and Transmission.
Morning, sirs. Paul McRae, Landscape Planner at LUC.
Good morning, Henry Collin with the LUC team, here to assist if there's any questions supplementary relating to the routing process. I was the environmental lead on the environmental team appraising the options for routing.
Morning, David Bell, Chartered Town Planner, advising the applicant on planning and policy matters. Thank you.
Thank you. And I know you've got more members of your team here, but if they need to contribute later, we can just introduce themselves if that suits. Okay, and then for Aberdeenshire Council, don't think we've got Mr. McIntosh yet. No.
Good morning, sir. I'm James Hewitt, Senior Planner with Aberdeenshire Council's Energy Team. To my left, we have Stephanie McMillan, who is a planner within our Energy Team, and we're here to observe today.
Thanks very much. And Angus Council, Mr. Findlay.
Yes, good morning, sir. My name is James Findlay, King's Counsel, instructed by Tina Kidd, who sits round the corner, but two to my right. Also to my immediate right is Carol Anderson, who will be giving evidence, and to Tina's right is Ed Taylor, who's a planning officer from Angus Council.
Thank you very much. Mr. Campbell, can you, good morning, can you let us know who's here with you from, well, introduce yourself, but also let us know who's here with you from No Teacup.
Good morning, sir. I'm John Campbell. I'm a retired King's Counsel. I'm leading the No Teacup group, whose composition changes day to day, but here we are. To my right is Eileen West, and to my left is Brian Wade. Both of those people will be assisting me. Mr. Ed Troughton sits to Brian Way's left, and going around the table, Mrs. Joyner, Mrs. Leslie Joyner, beg your pardon, Mrs. Angela Fraser, Mr. Mark Ansell, Mrs. Fiona Bick, who's not represented by me, but represents Exton Skene Community Council, Mrs. Sue Patterson, who is helping me, and has provided a hearing statement for Bankery Community Council. I'm sorry, I get lost then. It's Anne Shearer, isn't it?
Anne Shearer, Crathis, Durrison Remote Community Council.
Thank you very much.
And Jean Reid from Backfield Farm.
Thank you.
Yes, so thank you, Mr. I was going to come round to other parties because there's a bit of overlap between parties representing No Teacup and here on their own behalf. So we've got Ms. Patterson from Bankery and Community Council. We've got Ms. Shearer from Crathis, Namoke and Durris. Fiona Bick for Exton Skene Community Council, and Mrs. Reid on your own behalf. Is that everyone who is participating today?
There are those sitting behind me from whom I might seek assistance, but it's inevitable in a large group that there will be overlap, and we'll try so far as we can to identify that where it occurs. I'm getting a note here. I did identify Mrs. Taylor.
Okay, thank you. Okay, thank you. So we'll aim to break for some time for lunch around 12:30, 1 o'clock. We'll also have a short mid-morning and mid-afternoon break. We can hopefully fill up people's water jugs at that point. So when people initially opted into this session following the pre-inquiry meeting, you may recall we had many more numbers of people who said they wish to participate than are actually now participating. So anyway, because of that initial response, we had decided to earmark today for discussion of Aberdeenshire effects and tomorrow for discussion of Angus. Now that reduced number of parties might mean we don't need 2 full days that we've set aside, but we'll see how we get on. And hopefully you've all seen the agenda, and there's some initial kind of methodological issues that I want to go over first. Now what you're hearing from me this morning is that I'm the one of the two of us that have done the most preparatory work for this hearing session, so I'll be asking most of the questions, but not all of them. And Mr. Warren, on the other hand, has done all our preparation for the conditions hearing session, so you'll be hearing more from him on Friday. So as I said, we'll start off with some overarching methodological issues, then we'll move on to effects in Aberdeenshire. If we get through all that today, then we'll just stop. I don't propose to move on to effects in Angus, because I think some people who are only interested in that will only be here tomorrow. So again, just probably worth reiterating how the hearing will work today. Last week, for the community hearing sessions, people in turn read their statements. That's not how it's going to work today. It's going to be a structured discussion, I beg your pardon, led by us. So you should have all had access to the agenda. We've got all your hearing statements, the other written evidence. We'll take all of that into account. Rather than asking you to read out your statement today, the agenda picks up on those areas where we, having read and thought about your evidence, where we want to probe a bit deeper to understand that evidence. For some of the agenda items, we have few or no specific questions. But if we don't have a particular issue in the agenda that you've raised, that doesn't necessarily mean that we think it's unimportant. It's just that we think we understand where everyone's coming from on that issue, so we don't need to ask for any clarification. But that said, if you think there's a pressing point that we've missed, then do raise that as we go through the agenda. We don't want anyone to think coming away from today that they've not had the chance to say what they feel is important to say. So for example, if for an objector's hearing statement, we might perfectly well understand what's in there and not have any particular questions to ask about it, but you will have now seen the applicant's hearing statement and you might wish to respond to something in that, and of course vice versa. So we'll give people the chance to do that. And then going through the agenda, we'll decide when we think we've heard enough evidence, and we'll move on to the next point. And again, just want to remind people today that we are today only considering the landscape and visual effects of the development. Some of the hearing statements stray into other matters like effects on wildlife, effects on roads, and more general policy issues. We'll not be talking about those other issues today. It's just about landscape and visual effects. Does that sound okay to everyone? Okay, and any questions that anyone's got before we move on? Yes. Right. Okay, I'll keep that in mind. We've got some extra speakers as well, so we'll try and put them around. Hopefully that helps people with audibility. Okay, so if there's no other questions, let's move on to the agenda. So the first issue we want to talk about, well, the general first heading is overarching and methodological issues. The first matter we want to talk about relates to the limits of deviation. And the first point within that is what the practical limitations in the use of microsighting, including what microsighting can mean for the design of individual towers. So we're just interested in understanding a bit more about how the limits of deviation work in practice. So the questions I've got initially will be a series of questions for the applicants team, because they'll be the ones to answer those. But I'll bring in other people if they want to comment, and let me know if I don't do that and you want to speak. So what I wanted to do first then is look at a couple of drawings that will hopefully help us go through this. So the first set of drawings I want to look at are entitled Overview of Limit of Deviation Limitations. So for those of you who've got the reference, the numbers in the foundation documents list is 001.026. 001.026. So it's from volume 3 of the EIA report in chapter 3, and it's figures 3.3.1 to 3.3.29. So it's 29 different bits of paper make up that document. So I'll just give people the chance to find that. And once you've got them, if we can look at sheet 11, which is it's just so to use that as an example by way of illustration. Sheet 11, if you're struggling to find it, it shows the line between towers S69 and S85. Has everyone got that? Who's trying to find it, or do anybody need some more time? Right. Okay. So I'll just, as I say, I'm just going to go through this drawing just by way of illustration. So, as I said, this shows the line between towers S69 in the north and S86 in the south, and at its simplest, we can see the operational corridor between towers S73 and S76. So it's a straight line there, and there are two suspension towers between those two, being S74 and S75. And here the operational corridor is 90 metres wide So it's 45 metres either side of the alignment. Mr Burnett, I'm just going to go through what the assumptions I'm making here. So I guess if I go awry, just let me know. But I'll keep the questions rhetorical until we get to the kind of details, if that's okay.
It'll be primarily Mr. Grant will be answering.
Okay. That's fine. So we have a 90 metre wide operational corridor, and that's the thinner line either side of the thicker black line. And we have a 55 for these two suspension towers. For this simple part of the line, there's a 55 metre limit of deviation, which, if applied laterally and to the maximum, it could take the edge of the operational corridor all the way out to the broken orange line. Yeah. So between the alignment and the orange line on this straight stretch is 100 metres. 45 metres as part of the operational corridor, 55 as part of the limit of deviation. So we have 200 metres across between the two orange lines, and the operational corridor will be somewhere within that, and it will be 90 metres wide. Okay. And then if you look at tower S76, we can see that there's a wider circle around that, which allows for the tower location and therefore the operational corridor to be moved up to 100 metres. And we can see the kind of lilac coloured kind of shape underneath that, which is the cable pulling area. And so that would move with the tower, but it would never move so that it would go out with the orange line. Yeah, okay, good. So far, so good. So that would this first real question, I suppose, would the presence of the cable pulling area serve to limit the distance that, in practice, you could move tower? Well, let's look at S77, for example. It doesn't seem that you could actually S77. The cable pulling area to the northeast is right up against the boundary of the limit of deviation. So in practical terms, if you were to move S77 northeast, well, either you couldn't do that or else you could do it, but the cable pulling area would just have to be a bit smaller. And I wondered which of the two is correct there, if I'm looking at that drawing right.
I think the intention with that arrangement is that tower S77 wouldn't be able to be moved any further east.
Right. Okay. That's fine. So I wondered more generally, the cable pulling areas are not all exactly the same shape. So it looks to us like there's a bit of wriggle room in terms of exactly how you can figure that based on what's on the ground and the constraints. Is that presumably you have a minimum bit of space you need, but it's a bit of a movable feast. Is that right?
Yeah. So fair to say there is potential micro-siting that could be done 5-10 metres to deal with construction tolerances, but it's not movements out with, because it looks like we're trying to avoid impacting that adjacent woodland.
Yeah, I mean, I just mean this as I'm just using this as an example rather than any particular thing. So, okay, that's fine.
Well, I suppose in broader terms, that's not necessarily the only consideration we would have for moving an angle tower, because if you take S76 to S73, part of the restriction would be the LOD that you've got for construction, but part would also be the impact on S75 and S74. Where you move an angle tower, you also have to move the intervening suspension towers.
You anticipated one of my next questions, so that's fine. Good. Okay, then that's helpful. So again, just so as everyone here in the room's understanding, you know, what's in front of us. If we look at tower S78, just to the south there, and we can see the pink area to the southeast, annotated with the number 42, and that's an operational variation to the limit of deviation. So in effect, that means that the operational corridor just can't intrude into that area. That's correct, isn't it?
That's correct. That's intended to show.
Okay, that's fine. I know a couple of the representations to us had misunderstood what that the purpose of that was, so that may be helpful to people who are listening.
So I think the 42 annotation refers to a broader description of why that's restricted.
Yeah, and there's a schedule of those elsewhere, isn't there? Yeah, yeah.
So, sorry, yeah, that's in chapter 3.5. Chapter 3.
Okay, and then looking at the blue shaded area to the north of S78, that's a variation in the limit of deviation, which relates both to the construction and the operational phases. Yeah.
That's correct.
Okay, so that's fine. So no operational corridor doesn't come into that area, no construction activities take place in that area, and for example, in that example, we can see that you couldn't move Tower 78 too much further towards the northwest because the cable pulling area would start to then intervene in that area. Yeah. Okay, hopefully that everyone's clear on that point, on those points, and it helps clarify. So I just want to talk on a bit more about how on the ground all this plays out, might play out in reality. So as we've discussed, we can see that the limit of deviation, which is sought, is a 55-metre radius for a suspension tower. And for that type of tower, that's where the line doesn't change direction. Yeah? And so the insulators hang vertically rather than being in tension and almost horizontal. And there's different tower designs, a suite of different tower designs, depending really on the tower height. Is that correct?
Broadly, towers sit in two categories of suspension or tension towers. So the tension towers are for changing direction. They also sit within 10 degrees, 25 degrees, I think 50, 75 or 90, and that degree is the maximum degree of changing direction you can get for that type of tower. But then they also have individual extensions you can have depending on the height you need to achieve.
Okay, thank you. Yeah, and there's two drawings. I'll mention them. I don't think we need to go there just now, but just for reference. So there is 001.028, and that's, I think you maybe referred to it there. So that's the figure 4.4.1, which is tower design, and I think it's got 3 sheets of the different tower designs. And there's also a separate appendix 3.1, which is the tower schedule, which tells us which tower is what type of tower and its height and the information like that. Okay. And we can see the suspension tower is typically less bulky than the tension or the angle towers, which will come on to them. And for the suspension towers, it just looks from the drawings that there's never a need for a cable pulling area below them. Is that correct?
Say that again for a suspension tower? Yes. Yes, that's correct.
Okay, and then you mentioned the tension towers there, and these are when the line changes direction, effectively.
Broadly speaking, yeah.
And is there any tolerance in that? I mean, is there a tiny angle of change that means you don't need one of those towers, or is it just any change?
It's any change, really. I think there is a very minor tolerance, but in reality, it's zero.
Sorry, you're doing all the heavy lifting so far. Apologies. We'll move on. Mr. Wade, yeah, sorry.
Yeah, sorry to interrupt. You were just talking about the tower design drawings in the application. I can't remember the number, but I'd just like to ask the largest tower on the entire route, which is S96, I believe, which is also coincidentally on the highest ground, is apparently a design called ADJ, Alpha Delta Juliet. And there's no mention of that particular design in the tower design drawings in that section. So I was wondering, since it's so much bigger than everything else on the line, is this an even bulkier version of the pylons?
Right, so that tower doesn't appear to, there doesn't appear to be a drawing for that particular tower type, which I hadn't noticed. I don't know if that's something you can answer just now, Mr. Grant.
Yes, that tower is a DJT tower. It's for quite bespoke purposes where you've got extreme changes of direction, or for connections to the substation, which is where this tower is being deployed.
But we don't have a drawing of it, is that?
There'll be a drawing available that we can share.
Okay, that's fine. I've got a question about what happens when a tower changes height, but we'll maybe come back to that. But okay, so if that's something that can be supplied, great.
Sorry, did Mr. Grant say, it's just my fault, I didn't hear you, that there is a drawing, or there will be a drawing?
I believe we can supply a drawing.
There isn't one in the evidence just now.
I don't know if there is.
Okay, so we can pick up that particular point. Okay, so we've talked about the we're talking about the suspension towers, or the tension towers, and so they will always need a cable pulling area under them. Is that right?
The tension towers? Yes. Not necessarily, but in theory they could. Potentially you would want space of provision available for them, if you, not necessarily for the initial construction, but if you were to do any repairs or replacements, you would want to be able to repull from a particular location.
Okay, but in terms of the drawings we've got, I mean, it's not a huge point, because we can show where you're asking for a cable pulling area and where you're not. Without going through every single tower, it looked at us that, generally speaking, where there was a change in direction, there was a cable pulling area.
Can I just ask, in terms of the cable pulling areas, how much flexibility, if any, is there in terms of how much space you need for that purpose?
It would largely depend on the topography that you've got and how much space provision you have within that. So the intention of the pooling area as it's drawn would in theory be the maximum extent. If your topography suits and your requirements suit, you could potentially reduce that.
So in terms of what's shown on the drawings, is that the maximum amount of space that you anticipate needing in those individual locations?
Yes, I believe it's a generic requirement, as in the maximum area we would need, so in theory for many cases it would be reduced.
Excuse me, sirs. I couldn't actually hear what Mr. Grant said. Did he give us a figure for the maximum amount for pulling areas?
No, Mr. Grant, would you like to just repeat?
I don't have that figure to hand, but it's as per the drawing.
Okay, so as we've said, we've got a default limit of deviation for tension towers of 100-metre radius. And this is where you maybe anticipated my question, Mr. Grant. So if we can look at S75, tower S75 as an example on that same sheet. There's a microsighting allowance of that of 55 metres. But if you were to move that laterally so that it was out of alignment with the towers on either side of it, then that would need to become a bulkier tension tower. Is that correct?
That's one scenario that could come to be. So if you needed for whatever reason to move S75 on its own, and you needed to keep S74 and S76 where it was, then yes, you would need to change S74 to a tension tower, S75 to a tension tower, and potentially S76 would change to a different type of tension tower because it's got a slight angle on it. At the moment, you might need to increase that to the 25-degree change in direction type.
Okay, we'll come back to that. If that were to happen, then you would also need a cable pulling area under S75 as well.
Potentially, yes.
Okay, so for the existing tension towers then, I know this is a what if, and I just want to understand how these LODs might play out in practice. For the existing tension towers, sometimes the cable pulling area appears to be limited in extent, so that might be a constraint that you're trying to avoid. But in that scenario where 75 had to become a tension tower, we don't have any drawing showing where the cable pulling area would be. We don't know what constraints might be under there that we need. So that would be introducing a different element to the design if you had to go there. Is that right? Is that fair?
That would be correct, but that would also be part of the consideration about whether or not it's appropriate or beneficial to move the tower in that scenario, because you could be introducing other issues. The other point as well is, at this stage, there's not a technical preference to move any of these towers. It's only to manage unforeseen risk on site. That would potentially be an unforeseen risk on site. And whilst it might be preferable to have a pulling capability at each tension tower for that scenario, you might have to accept that that's not necessarily possible. And for certain types of tension towers, you can pull through the tower. So you wouldn't necessarily need it at that location, although it might have been beneficial if you were to design it in that way from the beginning. But a change at this stage, you can't necessarily have that benefit.
Okay, John, I understand that point. So just kind of taking that, thinking about that, and you might not be able to answer this because I think this is a question about how a consent would operate. Do you think, or is the applicant of the view that those limits of deviation would allow a suspension tower to become a tension tower with a cable pulling area underneath it? Is that certainly not explicit in the way the limits of deviation are framed? So I wonder whether you think it's implicit, because I think we'd assumed. Well, I'm just in doubt in my mind whether that's explicit in what the application requests in terms of limits of deviation. Because as I say, for all the tension towers, we have a wider limit of deviation. We have a cable pulling area showing, so we can think about what the effects of that cable pulling area are and factor that in. But we can't do that in the hypothetical if you felt you needed to change a suspension tower to a tension tower. So sorry, that's a long way of saying, does the applicant think that the limits of deviation allow you to do the kind of scenario that you outlined without any reference, well, within the parameters of the consent, I guess?
I don't think there's any presumption that we could build, if needed, a pulling zone out with the limit of deviation. So in theory, if we did feel that we need one, we would build it within the limit of deviation. That being said, it might be such that we would have to go without a pulling location in that area and have to pull through the tower itself and use the existing pulling areas to string that section of line. As I say, it's not the preferred engineering solution to do this at this stage.
Yeah, no, I understand that point. I'm just thinking it's the kind of what if question. So, I mean, you said out with the limited deviation. Now, I'm clear that you couldn't do it out with the limited deviation, but what you're saying is you think you would be able to do it in an area where the plan simply doesn't show that there's any cable pulling area just now.
Well, if you take the example at the moment between S76 and S73, to keep the operational corridor within the limit of deviation, you can see there's a limit to how far you could actually change that angle of deviation. And broadly speaking, if you come back behind the tower to pull, there's a limit to how far out with that sort of angle of deflection you would need to go.
Okay. I wonder whether, I mean, that's about what any consent would allow. I don't know whether either of the planning authorities have got a comment, if they were able to follow my convoluted questioning there about that particular issue.
Sorry, it was just to clarify, if it wasn't clear. If we felt that we couldn't develop a pooling area in a newly created angle tower, you can use the pooling areas of the existing tension towers either side, and you would just pull through that tower.
76, 73.
Yeah. So just for the avoidance of doubt, if 75 or 74 changed to a tension tower, you could still pull from S73 and S76 or S77.
Okay, so, and again, this is a what-if question. If we don't think it's clear enough, we might want to change what the conditions say to make it clear that the micrositing allowance doesn't confer any permission to put a cable pulling area where one isn't shown just now. I'm not saying we would do that, I'm just thinking through how we might, because we'll come on to the conditions on Friday, but that's one of the things we've been thinking about. So does that, if we were to do that, does that sound problematic? Maybe that's something to come on to on Friday, if not today.
I think we'd need to come back to you. I think we'd need to come back on that.
Can I ask something? Does that also imply you can change the size of the pylon if you change its use?
I'm not sure I understand the question.
You were asking about the change in so maybe if I'll say what our understanding is that yes, the limits of deviation being sought would allow a change of location up to the parameters we've talked about, and it would also allow a change in tower height of up to 9 metres. So the two things could happen at the same time. Yeah, that's my understanding. Yeah.
That is correct. A new location for a tower might necessitate a different height of tower to achieve the clearances.
Or there might be some other independent reason why then. And so just on that question, I'm not thinking about a change of tower type, but just a normal suspension tower, and for whatever reason it needs to be a different height. Looking at the schedule of towers, the heights are all very specific and they appear to go up. So it looks to us that rather than a kind of bespoke change of height, what you do is just select one of the next highest tower type that you need to use. Is that how it works?
Yes, so the towers are built in sections, in 3 metre sections, so if you need to increase your height, it's probably within 3 metre increments.
So the practical effect of that, if you change a tower height, you're just selecting a different tower from that schedule. Yeah, those designs are already there.
Yes, that's correct.
So is that, so you said something interesting there about the 3 metre essentially, or the kind of modular approach to tower design in 3 metre increments. Is that the reason why there's a 9 metre vertical limit of deviation proposed?
Yes, in theory you could go up 3 section sizes. I just wanted to add a point of clarification about how the LOD could work as well for suspension towers. It's not necessarily just a case that they could move laterally, they could move along the alignment. And that wouldn't require an EPZ, a pooling zone, to be introduced.
Yeah, no, indeed.
May I ask a question?
Yes, Mr. Wade had put his hand up, so I'm going to ask him to allow him to.
Yeah, thank you for that. Just a more fundamental question on LODs. It appears that for analogue projects like the Norwich to Tilbury project being proposed by National Grid at the moment, they seem to be able to operate under very less, how should we say, liberal LODs. And they talk in terms of a 3 metre, a 5 metre kind of maximum height variation. I was wondering if the SSEN can explain why they require much larger limits of deviation than analogue projects.
Okay, I mean, that's a fair question. I don't know if there is an explanation of that, Mr. Grant.
I don't know the specifics of Norwich to Tilbury. But
Yeah, I should say, and neither do I. I suppose, I guess, why 9 metres here would be the question.
Usually around the variation to topography that we have, probably quite variable. If you think the terrain around this area is potentially quite undulating, you don't necessarily need to go a long horizontal distance to result in a different vertical distance, so it provides that flexibility.
Thank you. If the tower is changed out, if a tower is changed out for one that's 9 metres higher, is that 9 metres added at the top, or is it added at the bottom so that the top becomes higher? So does the tower also become wider at the bottom as well as taller?
So I don't know if you want to, you've probably answered that to me already in terms of the tower schedule, but if you want, maybe you can explain, Mr. Grant.
Yes, the base would get larger if it needs to support a taller structure.
Hi, I just wanted to ask if the 9 metre vertical limit of deviation for this line, Mr. Grant referred to it being due to the topography, which is variable in the area, but the topography doesn't change between design and installation. Similarly with other lines where we've heard the limit of deviation is lower. So I'm still wondering why, in this case, we need such high limits of deviation.
So the purpose of the LOD is to manage unforeseen construction risk and issues. So potentially ground conditions that might arise during the construction phase, or protected species that might well have moved in, or potentially to reduce overall impact through condition. And therefore a change in tower location, it doesn't necessarily need to be a massive change, could result in the tower being located on different topography, or indeed introducing new topography between the spans, which you now need to oversail. So you do need that flexibility to manage both the lateral moves and the vertical moves.
Sorry, I'm just wondering why that's different from any other project.
I don't believe it is different from any other project. I don't know National Grid, from what I gather from colleagues, have let me know that it's quite flat, and maybe the topography is more suitable to having a reduced limit of deviation.
In terms of just sticking with the vertical limit of deviation for a moment, there's a 9 metre limit for every tower type proposed. Obviously, there's a great variation in tower type. I mean, why was it preferred to go for a blanket 9 metre variation over, for example, a 20% variation that would be proportionate to the size of the tower proposed?
Depending on what size of tower you had, if you stuck to 20% or 10%, it might result in you being between extension sizes. So if you've got a 50 metre tall tower, odds you couldn't put on 3 body extensions.
Okay, but you could fall into the category below the next modular step, essentially.
Yes.
Okay, sorry.
Yes, sorry to interrupt again. Going back to my favourite topic, it's tower number N96. I think I said S96 earlier. It's got another name locally, but it's not to be used in public. That tower is already 72 metres high on the schedule. So with a limited deviation, we're talking a possible 81 metres high tower, as I said before, on the highest ground in the entire route. Is it reasonable to have that kind of limited deviation on that size of tower to make something that's totally unprecedented in any project, to my knowledge, of this type? I don't think any landscape assessments or anything have been done with an 81 metre tower in the line.
I don't know, would you like to answer that, Mr. Grant?
I think we've applied the limit of deviation to all the towers.
I have got a question about that and what the RVAA says about limits of deviation. We'll maybe come back to that that point. Okay, so right, that was useful, your explanation, and I wasn't sure what your view would have been on what the limits of deviation allow. I think one scenario that we had anticipated might be the case. So, for example, again, just looking back here as an example, and you see S73 as a tension tower there, and you see S77, the tension tower at the bottom end, the south end, and there's a straight, oh sorry, S76, and there's a straight line in between them. I think we wondered whether, if for any reason, for example, you had to move S73 a long distance to the northwest, or you had to move, or you had to move S76, let's say to the southeast, that would affect the alignment, and that therefore you would then adjust S74 and S75 so that it remains a straight line between the two tension towers, rather than just moving one tower and consequently the next tower along then has to change designs. I don't know what, in reality, what's the most kind of default assumption or the most likely thing that you would tend to do. Understand what I mean there?
It would really need to be considered on an individual basis as to what results in the least overall disruption. As I said before, it's not the preferred technical solution to be moving towers at this stage because of the issues that it introduces. I think overall the preference would be to move the least amount of towers, because it has a knock-on impact on foundation design, working platform design, access track design.
Okay, yeah, I mean I get that, but 100 metres is a big limit of deviation, and when you say that, then 100 metres sounds like a long way, and that's what's being asked for. So we just need to think about what are the possible implications of utilising that. Okay, that's all I was going to ask you on that kind of very first point under item 1. So before I move on to number 2, or the second point under item 1, sorry, which is about the basis for the LOD variations insofar as they affect residential visual amenity, are there any other questions, Ms West?
Mr Grant said he didn't know of any other projects that had different limits of deviation. Norwich to Tilbury is 6 metre vertical LOD. Bamford to Twinstead is 4 metres. I just thought he might like to know that.
Okay, thanks.
Sorry, yeah, I've just got one more question on in terms of how the project could change within the scope of the limits of deviation. So, I suppose my question is, does on the face of the consent, would the face of any consent allow for a change from a suspension tower to a tension tower, or vice versa, given the nature of the structures are of a different appearance? So if I ask you, Mr Grant, then I'll ask for the views of the planning authorities, please.
Yes, I believe it would.
Mr Finlay, or others?
So I gather your question was really about tension towers and suspension towers and if they were changed. So maybe a suspension tower became a tension tower, is that correct? The tension towers are more sturdy in design, and I think that has visual impacts, a greater degree of visual impact than a suspension tower. And there could be some implications if some of them were swapped out, particularly if they were lying close to some of the residential properties. Certainly in the residential visual amenity assessment, quite commonly it is stated in the assessment whether a tower is a suspension or a tension tower or angle tower, and that would have implications in terms of the magnitude of effect experienced from close by residential properties and other views as well.
And in terms of the kind of face of any consent, do you think that would extend to the interchanging of tower types in that sense? So would the consent allow a suspension tower to be changed to be altered to a tension tower as part of those limits of deviation?
I think we need to take some time to consider that, and we'll come back to you whether today or tomorrow, but we'll try and come back to you on that.
That's fine. It's something we can revisit in the condition session anyway, because it is relevant to the micrositing and LOD condition, so we can pick that up then, so you've got time to give that some thought. Mr. Hewitt, is there anything that you would like to add? No? Okay, thanks. So I think on reflection then, yeah, let's pick that up on Friday, but no, I think, yeah, we'll stop there. And, yeah, let's leave that there for now. Thanks.
Okay, thanks everyone. So let's move on then to the second point under agenda item 1, which is kind of Roman numerals 2. So, and this was...
Excuse me,
yeah, sure.
excuse me, sir, I had one last question, if I may. I just wondered if the extensive limits of deviation for this project are to compensate for, as Mr. Grant said, unexpected protected species or unexpected topography. And I wondered if that was to allow for the fact that the environmental impact assessment was so flawed.
Yeah, we can answer that if you want, Mr. Grant, but
I mean, obviously don't accept that there's flaws in the assessment, and then I think Mr. Grant's explained what the reasons for the LODs are for unexpected events in the future.
okay, let's move on then to number 2, Roman 2, under that first point. So this is the basis for the proposed limit of deviation variations insofar as potential effects on residential visual amenity are concerned. So first, I just want to focus on an extract from Chapter 9 of the EIA report. It's short, so I'll just read it out, and then we can just take the questions from there. And there's also a very similar thing said in the applicant's hearing statement. So if people want to have it in front of them, it's so Chapter 9 of the EIA report. So the document number is 001.011. It might be worth having that up because we might come back to it anyway.
Could you give a title of the document, please?
Yeah, of course.
So we can obtain, get it from different directions.
It's the Environmental Impact Assessment Report, and it's volume 2 of that, and chapter 9. And I'll give you the paragraph number in a minute when everyone's found it. And so, I mean, I know you seem to be struggling to find it, Mr. Campbell. It's maybe not essential right now, but for those who've got it, it's paragraph it's paragraph 9.3.25. Okay, so this is where the report is explaining how the limits of deviation feeds into the assessment of the landscape and visual effects. And it says, where the horizontal or vertical limits of deviation are considered to allow a design that would result in a different level of effect than that found for the proposed development, commentary on this and a secondary judgment is provided. Do you see that, Mr. Grant? Yeah, okay. Just thinking about that, where there's in effect a modification of the judgment as a result, or the assessment result as a result of the limitation, the applying, if you were to apply the limit of deviation. So where such a secondary judgment is arrived at, is that set out in Chapter 9 itself, or would that tend to be in the more detailed assessments in the technical appendices?
I think it's probably more a question for Mr. McCrae.
So the judgments would be in the appendices.
Can you show me an example of where that's done in one of the appendices then?
Not off the top of my head, no, sir. But we can look one up and find one for you, if that would be helpful.
Yeah, I mean, I'm particularly interested. It seems to be most likely to be relevant in the RVEA, and I couldn't see any examples of that in the RVEA. So the EIA report and then the hearing statement explains that there are secondary judgments made, and I'm not saying they're not there. I just need to see some of them just to understand how that works. Okay, so maybe we can come back to that later today. Then maybe if we or tomorrow indeed, if possible. Okay, so I can put that aside then just now. I want to turn to a passage in Liz Bowen's report, Mr. Campbell, which focuses on the approach in the RVEA. So that's her expert report, if you like. So it's document 022.019. I'll read it out, but it's probably worth having it in front of you if you have access to it. In that extract, which I'm going to read. So yeah, so it's paragraph 4.8, and it's the second point in paragraph 4.8. But at this point, the quote I'm going to read out is referring to the RVA, if people want to have that. But we'll start with Liz Bowen's quote. So it's 022.019, Liz Bowen's report, and it's paragraph 4.8, second point. So it says, in fact, sorry, if people got that in front of them, yeah. It says, the assessment of effects, there's going to be a question for you, Mr. Campbell, initially, then I'll come back to the applicant. The assessment of effects on residential visual amenity and whether the threshold is reached is based on the existing layout of the alignment. Whilst the potential changes which may occur as a result of changes within the horizontal limit of deviation are discussed briefly at most properties, the threshold is not reassessed in this context. Given that the horizontal limit of deviation can be up to 100 metres, towers may be positioned close enough to properties to trigger the threshold test. So I think the point being made there is that that maybe that there isn't, but should be an overt reassessment of whether the threshold will be passed if the full limit of deviation were to be used. And again, just picking up, Mr. Campbell, in your hearing statement, I don't think we need to go there. It's a very short statement, but in your executive summary of that, it's document 0. Your hearing statement is 022.017, if people want to see it. But you say, page 3, right-hand column, third point down, just in short, you say the limits of deviation materially increase the risk of overbearing effects and should be fully assessed. So I'm just thinking about what is in Liz Bowen's report and what you've said there, Mr. Campbell. Can you explain what you mean by should be fully assessed? Are you and Liz Bowen saying that this is more work that the applicant should do or should have done in the RVA itself? Or are you saying now that's a task for us, and is it deficiency in what we've got, or are you saying that's now our job based on all the evidence that we've got, and you say it should be fully assessed?
No, I think I'm saying it's the applicant's job. Necessarily, if the limit of deviation is operated, there exists a possibility that the residential visual amenity threshold will be crossed. It's therefore necessary for the applicant to make that assessment on the assumption, sorry, just stop typing for a minute, on the assumption that the threshold, that the limit of deviation is triggered. I didn't put that very well, may I try again? The applicants come to you asking for a limit of deviation in every case. The evidence of Ms. Bowman, and I think Ms. Anderson as well, is that if that limit of deviation is triggered, either partially or fully, there exists a possibility of a change in the visual impact. That change in the visual impact may or may not take the visual consequences over the threshold, which is explained in Landscape Institute Technical Guidance Note 19. Therefore, in coming to you for that permission, the applicants should have assessed that, and we think they haven't, and ought to have done. So we point this up as a flaw. I'm nervous about the word flaw, but as an omission from the Environmental Impact Assessment Report. I hope that's clear.
So may I follow up on that? I think it's the right time to do this. Forgive me if it's not, but it's also referring to Liz Bowman's report, and it's on page 47. And it's referring to Tower S111, Kirkside of Lochte, where she says, shall I slow down before everyone gets that? Or shall I just carry on? I'll just carry on. That the HLOD of S11 is unrestricted at this location, which means it could move 100 metres northwest towards the property, and I believe this is what we're talking about. At that point, the LHOD would bring the tower 64 metres from the edge of the garden, where, if visible, the top of the tower and the conductors would be visible at an angle of 45 degrees, and the effects would be severe. That doesn't appear, I don't believe, sirs, in the applicant's documents and assessment of RVAA. So I think it's just an example backing up what we've been talking about.
Okay, thank you. No, that's a helpful example. We may well come on to talk about that tomorrow, but it's an illustration maybe of the point that I take to be being made by Liz Bowman and John Campbell and Mr. Campbell. Mr. McRae, if you get any comment in response to what you heard there.
Yes, of course. So in response to the first question, which was about the sort of reassessment that Liz Bowman is talking about, so there's not a formal reassessment of, you know, the absolute worst case in every occasion, but in terms of the limits of deviation making things worse, so we've already included the limits of deviation to define the study area for the properties that were examined. And in the cases where limits of deviation could result in the properties becoming, you know, overly close to particular towers, then limits of deviation variations have been introduced, and which were shown in the pink areas on the plan that you were looking at earlier. So those areas have been taken into account. With regards to the example raised by Mr. Troughton, so I'm just trying to find the right page on the figure. But the LOD restriction, the LOD is not restricted in the same way as the others, because there's already a cutout of the limit of deviation, which is shown as the orange dashed line on the figure, which is figure 339 in the series that you were looking at earlier. So it's my understanding that it would not be feasible to move the tower S111 by 100 metres northwards. And Mr. Grant may be able to clarify that further.
That's correct, yeah. So you can see on that figure that Paul just referred to, there's actually been a physical reduction of the LOD around Kirkside of Lochte that would limit how far north you could actually move S111. You can see that the operational corridor will contact the boundary of the LOD at Kirkside of Lochte before you can substantially move S111, 111 any further north.
Yeah, okay, and we can maybe come on to that tomorrow. But just my understanding, you see the north part of the operational corridor is 30 metres or so south of the corner of the limit of deviation. So as soon as you move it 30 metres in that direction, you can't go any further because the limit of the corridor then butts up against the edge of the limit of deviation. That's what you're...
That's correct. So that would in effect limit how far north you could move S111.
Okay, but we can maybe talk about that in more detail tomorrow. Is that specific example, Mr. Wade?
Yes, thank you. So can I just conclude that what we've just talked about, within the limits of deviation that the applicant is asking for, we can have a scenario where we can increase the height of a pylon by 9 metres, we can move it and its associated pylons by 100 metres, and we can change the design to a pylon that's got an effective volume. I think it's something like 300%. I'm not sure, because the angled towers are so much bigger base, and of course the bigger the base, the bigger the volume by the square, which the volume is a visual effect. So we've got a scenario where we can increase by 9 metres move 100 metres and make, 200-300% bigger, or within the LODs. So that just trashes any visual impact assessment, surely.
So yeah, my understanding is well, you can move suspension towers 55 metres and angle towers 55. There's the 9 metre limit of deviation. What that means for volume, I don't know. I haven't looked at that in detail. So that's my understanding of what's been sought, yeah. Okay, so I guess another question for Mr McRae. It's related to this, but it's just coming at it from a more general angle. And you described there, or explained there, that for different properties you've applied limitations, restrictions on the limits of deviation. So it's a more open question then. Can you explain how you went about doing so? How did you determine which properties needed this, and then how do you then determine the extent of that restriction that you think you should apply to the limit of deviation?
Yeah, of course. So for the most part, it's the closest properties to the towers, as you would anticipate, and the ones that are most likely to be closely affected. In terms of how we've defined the areas, our sort of starting position was to suggest that there was no movement towards those properties, and then there was a sort of, we had a kind of negotiation with SSE and the contractors. They wanted to retain some flexibility, so we reached the position of the LOD restrictions that you can see on the plan.
So in doing that, there's a compromise or a balance that has to be struck, or that you struck, between, I guess, a kind of minimisation of any further encroachment versus, I guess, operational and construction concerns.
That's correct, sir.
And is the kind of approach or process or parameters to that set out in any documentation that we have, or is that just a more internal kind of dialogue as the design is developed?
I don't believe there's any detail of that dialogue, so no, the outcome is the variations which are shown on the plan and listed in table 3.1, and that provides a short explanation for the reasons for introducing each of those.
Okay, so it's a matter of professional judgment, but that's also tempered to some degree by the realities or the other constraints which come to bear. Okay, that's helpful. Is that okay for everyone? I said that I wanted to come back on a factual point about tower height. So, Mr. Wade, you referred to the 71 metres tower, the tallest tower, and the vertical limit of deviation is 9 metres. Now, we, and this could be wrong, had taken from the application documentation that 9 metre vertical limit of deviation applies regardless of tower height. So in theory, that 71 metre height 1 metre high tower could be 80 metres. I wonder if we can look at the RVAA. So that's document 001.288. And it's appendix 9.3 of the EIA report for those of you whom that might help you find it easier. Have you got that, Mr. McRae? Yeah, so if we look at paragraph 2.4.6, and that says, I think that says that the absolute maximum tower height for any tower is 72 metres. Is that, I just want to know what the correct position is. Is that your understanding that the limits of deviation wouldn't allow any tower to go beyond 72 metres?
No, I think my understanding was that it would apply to all towers. I'm not sure why that implies that it's not. Mr. Grant can probably clarify that, but I think the very tall tower that's being referred to is not a tower which is engaged in any of the RVA issues in any case.
But that's just a bit of loose wording then. I suppose you've not made an assumption in looking at all the towers that none of them would go above 72 metres.
No, that's correct.
Okay, so you've assumed the RVA regardless of what that says there, the RVA presumes upon the assumption that any of these towers could be 9 metres taller.
Yes, that's correct.
Says, may I ask a quick question?
Yes, of course.
We've been talking about maximum limits of deviation there, but I just wanted to ask the applicant through you, sirs, if I may, do they have a look at minimum limits of deviation through sensitive areas, such as Lipo woodland? And do they try and, obviously I would have thought through sensitive areas they would try and minimise the limit of deviation as much as possible?
That's fine. I mean, we're talking about limits of deviation. I'm only really interested in landscape and visual effects today, but since we're on that subject, that's fine. I don't know if you've got a response to that, Mr. Grant.
Yeah, we have restricted the limit of deviation in sensitive areas. Looking on figure, can't find the page, I had it open a second ago, where we cross the River South Esk, you can see it's restricted to construction activity. That's on page 6.
Could you repeat?
Sorry, I can't. None of us can hear that.
Yes, we have restricted the limit of deviation in sensitive areas. You can see some of the examples on page 6 of the limit of deviation variations, where we've restricted it crossing the River South Esk, and there's other examples throughout the figure.
It's perhaps worth just noting as well, there is a condition which we will be looking at on Friday that relates to micrositing and limits of deviation. And within the proposed condition, there is a section relating to sensitive areas, and they're defined. But I do want to talk about that on Friday, so we'll come back to that.
Thank you.
Okay. I was planning to move on then to item 2 in the agenda, which is about the visual receptor areas. It's actually it won't take as long, I don't think, to discuss that issue. So the kind of, yeah, the only item under that was to clarify our understanding of how the visual receptor areas are used in the assessment of visual effects. So I don't think we need to get this particular reference up, but I'm just going to quote from Chapter 9 of the EIA report. And at paragraph 9.4.52, it says, when talking about the visualisations we have from the specific viewpoints, the viewpoint list is a representative selection of locations that have been consulted on with statutory consultees. It is not an exhaustive list of locations from which the proposed development will be visible. It's intended as a representative list of locations from a variety of visual receptor areas across the study area. Impacts on viewpoints are not assessed directly, but visualisations from each location inform the detailed assessment of effects on views. It goes on from the visual reception areas across the study area. So that's fine, but just so as we're clear, that's explaining the viewpoints are there, they're illustrative, they're to help us or to help anyone inform an assessment of the effects on all the visual receptors. That's the relationship between the viewpoints and the visual receptor areas. I mean, is that broadly correct?
Yes, that's correct.
Okay, so I just want to pick up on one point from, only one point in this agenda item, to pick up from Liz Bowen's report about the effects on recreational receptors, and I'll give the applicant the chance to respond to that. So again, that's document 022.019. And it's paragraph 4.4, the first bullet in paragraph 4.4. So again, I'll just read that out if people have got it. So, although recreational receptors are assessed, this is Liz Bowen's report, although recreational receptors are assessed and listed within the assessment of VRAs, they are often not assessed in sufficient detail to identify individual effects. Also, they are not listed as being amongst the significant effects in the VRA assessment tables in Appendix 9.2 or in Table 9.4. For example, looking at VRA A8, Ark Hill, Balkello, Craig Isle and Gallow Hills, although Core Path 208 is listed as being in the area of large-scale change, it and recreational receptors using it are not drawn out in the description of significant effects. And similarly in Table 9.4, it's not listed in the conclusions. There's two Table 9.4s in Chapter 9 of the EIA report, that's the typo, but I'm assuming it's the one starting on page 69 that she's referring to. And that's the summary of significant effects. So if we can just bear in mind what I've just said, if we can look at that in Chapter 9 of the EIA report, Table 9.4 on page 69. It's document 001.011, if that helps anyone. It's page, yes, Table 9. There's two Table 9.4, so it's on page 69 of the PDF, I think. Maybe 71. It's the one. It's called Summary of Significant Effects. That's the table I'm looking at. Is it 71 in the PDF? Sorry. Do you see that, Mr. Campbell? But, yeah, no, it's fine. So anyway, what that table does is it lists all the residual significant landscape and visual effects. And I think what Liz Bowen is saying is that recreational receptors aren't assessed in sufficient detail. I'm just summarising. Aren't assessed in sufficient detail, and certainly the effects on them are not captured in this table. Mr. Campbell, that's the point, broadly speaking, being made by Liz Bowen, yeah?
That's the point that comes out of the first bullet at paragraph 4.4, which you read. So yes, she's saying that.
Okay, so I just wanted to give the applicant a chance to respond to that particular angle.
Yes, so the summary table that you're referring to is simply that. It's a summary. It lists the visual receptor areas, but the detail of what's been assessed is presented in the appendices. It's probably fair to say that there's not exhaustive lists of every recreational receptor and every core path. And clearly there is, in Scotland, a right to roam. People can walk for recreation in just about all parts of the countryside. So there's not an exhaustive appraisal of all those receptors. But I would point out for the magnitude of judgments for each visual receptor area, it does describe where the area where the most or the largest magnitude of effects would occur. So it can be inferred from that what visual receptors and including recreational receptors would be affected.
Okay, and if we go to the appendices, there's more detailed assessment on each of those receptors.
Yes, there's a detailed assessment of each of the receptor areas and the individual receptors within those.
Okay, thanks. Okay, the next item is residential visual amenity assessment, and there's a few elements to it, and it might take us a wee while. I'm wondering whether this is as good a time as any to have our mid-morning break. So if that suits everyone, shall we just come back ready to start again at 11:15, please? Yeah. Thank you. everyone. That's the end of our break, please. So let's make a start.
Mr. McRae's not back.
Mr. McRae's not back yet, so I'll wait a minute or two till he returns. While I do so, and not wishing to be partial, I've been handed a flyer for a local bakery, so if anyone's looking for something for lunch, I'll leave this down here. Okay, so item 3 then is about residential visual amenity. And before I move on to the specific items in the agenda, people may recall we'd asked clarification from the applicant on what seemed to us to be some discrepancies in the distances between the wireline, the wireframe drawings and the text in the RVAA, and the applicant provided a paper on that, which we asked to be circulated to people, so hopefully you've had a chance to see that. That responded to our questions. But I just have a couple of questions just relating to that, just so as I'm clear about what that's telling us. So, have you got that in front of you just now? Yeah, okay. Right. So that paper confirms that it's Ordnance Survey address data points which are used as the location from which to generate the wireline drawings for each property in the RVA. That makes sense. Is that normal practice when you're doing an RVA?
Yeah, that would be standard practice, yeah.
Okay, so those data points are generally thought to be sufficiently reliable indicators for the location of the house and the property?
Yes, they're usually the centre point of the building, the house itself.
Okay, we might come on to one or two examples, maybe tomorrow. But so as I'm clear, then, if I'll just pick up one of the properties. So this, I'm just looking at one of the wire lines from the RVA, just by way of an example. So I've chosen Dunswood because I know Ms. Joyner made comments about this, but it's just to illustrate the general point. I don't know if you have that available. And it's a very minor point, you might not even need to see it, but it's drawing A9.3.18. Yes, so it's one of the wireline drawings that accompanies the RVAA, and it's A9.3.18. But it's just a general point. You probably don't need to have it in front of you necessarily. So we've got the wireline here, and there's a little thumbnail in the bottom right-hand corner which shows the location. And I mean, it's at quite a large scale, but it shows the dot and then the view shed for the wireline as a kind of cone coming out from the point in the property. So, as I say, I know the scale doesn't allow us to interrogate this in fine detail, but in terms of is the data point that you refer to, is that automatically plotted onto that little thumbnail? Yeah, so it's not done manually. That actually shows the. So regardless of any dispute or discussion about where that point is in relation to what's on the property, that map at least shows the precise location of the data point. Yeah. Okay. Right.
Didn't put my mic on, but yes, that's correct.
Okay, that's fine. It just shows I was clear about what we're looking at if we're out in the field. That's fine. I don't know if anyone's that paper wasn't on the agenda, but people have seen it since. I don't know if there's any other points anyone wishes to raise if they'd have the chance to see that clarification paper. No. Okay. So let's move on then to the first point, which is the distance threshold that was adopted for scoping properties either into or out of the RVA. And I want to look first at Liz Bowen's report. So, in there she's quoting the Landscape Institute's technical guidance note. So Liz Bowen's report is 022.019, and I want to look at paragraph 4.8 of that. I don't necessarily think we have to get the guidance note up at the same time, but we can go to it if people want to. So, just reading from Liz Bowen then, at 4.8. The Landscape Institute Residential Visual Amenity Guidance, Assessment Guidance, page 10, para 4.47, states, for example, when assessing effects of overhead transmission lines, generally only those properties within 100 to 150 metres of the finalised route are potentially considered for inclusion in a RVAA. However, the height of the OHLs is not specified in this example. And I guess the point in the final sentence being made is, I assume that these proposed towers are at the taller end of what you might see in an OHL. But I suppose, questions to Mr. Campbell, doesn't the lack of reference to any height in the quoted passage from the technical guidance suggest that it should apply to any OHL, regardless of its height? And I suppose, therefore, that the approach which takes a 170 metre threshold to account for the micrositing allowances, it would be in accordance with the guidance.
I'm not sure if you're saying that the height of the turbine, of the pylons, the towers, with or without the LOD, is relevant to whether or not it crosses the threshold. Are you saying that, forgive me asking you a question, but are you saying that it doesn't matter what the height of the towers is, the threshold will be the same, the distance, the permissive distance will be the same distance away from the subject?
It's more at the stage of whether we're scoping in what properties are even assessed in the RVA or are not assessed. That's what I'm interested in.
Yeah.
And the guidance says 100 to 150 metres.
Yeah.
It doesn't specify a height. The implication from what I may be implying too much, what I'm reading from Liz Bowen's report is kind of saying, well, these are quite tall. She says, however, the height of the OHLs is not specified in this example. And I take the inference to be that if these are very tall pylons, then maybe 150 metres isn't large enough. But the converse I'm putting to you is that it doesn't specify height at all. Therefore, the other way of interpreting that would mean that it applies to towers of any height.
Well, that is one way of interpreting it, but I think it must follow as a matter of logic, if I may say so, that the taller the object, the greater the distance from the subject property. Doesn't that make sense?
It does, and it gives a range there, 100 to 150, which might speak to what you...
This is not the place for widespread criticism of this technical guidance, tempting as that might be. 100 to 150 is what the Landscape Institute came up with. They don't say why, but what I'd like to leave with you is it must be axiomatic that the taller the towers, the greater the distance over which they could have an impact. And the professional judgment comes in, as you know, in stage 4 of this process, where the assessor has got to make up his or her mind whether or not it's overbearing or making the place an unattractive place to live. The taller the towers, the easier that must be to achieve if you're closer to the house. I'm not putting that very well, but I think you see what I mean.
No, I do. I do.
Yeah. Could I make a point, please? You said about at the upper end of the scale for the size of these pylons. could I point out that the size of these pylons in the UK is totally unprecedented. This is a unique version. These pylons are bigger than the ones on the Bewley-Denny line by a margin. I think the figure I read was 80% of the pylons on the Bewley-Denny line are lower than the 57 metres reference value for teacup. So these are the Bewley-Denny line pylons on steroids. So the precautionary principle would say if you've got a region of 100 to 150 metres, you would assume that the precautionary principle would dictate your choice of which of those two numbers to use.
Okay, and the number chosen is 170. But just on that point, and you'll have seen from the agenda that we have asked parties to point us where we might look for comparable, if indeed there are any comparable pylons elsewhere. You said these would be the tallest in the UK. I think that's what you said. Is that your understanding from the? I don't know if you have that information from the applicant's point of view.
I don't think I'd be in a position to definitively state that.
If I could interject, there are pylons that are taller in the UK. There's a crossing over the Thames. So obviously they have to have very significant clearance for two pylons over a river crossing. But this is the largest overhead line run of pylons in the UK.
So okay. May I make a comment? Yes. I mean, from the background reading that I've done, an assessment of the threshold and the distance is always an element of judgment rather than actual measurement. And in fact, indeed, in the LI technical guidance note, a reporter reporting on the Bailey Bardnahy wind farm near Thurso, called David Russell, assessed any assessment of acceptability in these circumstances relies on judgment rather than measurement. And if I may ask you, sirs, through you, the applicant, how did the applicant make the judgment of whether an RVAA or indeed an impact on the limited deviation change was needed? How did they do that? Did they visit every property in question? I know we're going to discuss Lochte tomorrow and various other smaller areas, but it's a very important question as to how that RVAA was, how did they actually make a decision whether an RVAA was needed or not? Because none of them, other than you, sirs, came to our particular house, and I know other houses in the region.
Okay, so I asked the question earlier about how did you decide where, and if so, to what degree to restrict the limits of deviation. So I have an answer to that, so I'm not going to ask that again. But your question was, which I'll pass on to the applicant, how did you decide whether or not you needed to do the RVA at all for any particular property? So, yeah, okay. Sorry, just if you wanted to answer that.
Yes, sorry, of course. So the selection of properties was based on the definition of the study area, which we've discussed. Depends on this distance of 170, and we agree that the distance in the Landscape Institute guidance, it doesn't provide an example. It is a range to allow for the fact that there are a range of tower heights used in this type of project. So we opted for a measure that was bigger than that, 170, and we've added the limits of deviation onto that, and that's how we've determined which properties would be scoped into the RVAA itself in terms of the selection.
Kidd. Can I just draw to your attention that we've had numerous members of SSEN representatives in our home, and only one, who shall remain nameless, acknowledged that indeed that the alignment in facing us ahead of our home was questionable. She didn't elaborate too much, obviously, but yes, there was one representative who did acknowledge that the alignment was unsatisfactory. And I've had numerous members in the House who simply wouldn't acknowledge, refused to acknowledge, but one did.
And if I may add to that, sir, to the applicant's answer, I think I read into it that it was just a desk-based job. It wasn't done by looking at actual residential amenity as opposed to residential visual amenity. How would the house, how would the residences, how would the land be damaged by these things? They just did it from a desk. And that's what I'm reading. I may have misunderstood.
Okay. Sorry, Ms Anderson, you wanted to speak a while ago and I forgot about you.
Actually, Mr McRae answered the question, or that I was going to state, was really about the study area for the RVAA. And just to recap what I was going to say, in the document itself, the RVAA, it does indicate that the LI guidance doesn't state the heights of turbines that it's referring to. And I think quite sensibly they did decide on that basis to increase the study area for the RVAA. That doesn't mean to say that I think it was sufficiently wide enough to encompass all of the properties that would be significantly affected in terms of their visual amenity, but we can come on to that once, in relation to the specific questions you're going to ask later.
Okay, thank you.
Can I...
Sir, just for your reference, this is all set out in the methodology section 2 of Appendix 9.3, Volume 5, the choice of the 170 metre.
Can you give us that reference again, sorry?
It's section 2 of appendix 9.3. It's paragraphs 2.1.1, and the definition of the study area is at 2.2. If you read that section, sorry, it refers to the guidance and then the selection of the 170 metres, having had regard to the 100 to 150 metres referred to in the guidance, and then the addition of a further 55 metres for the limit of deviation as the definition of the study area.
May I say something, please? Sure. Thank you. I was wondering, what evidence does the applicant have that properties beyond that distance wouldn't experience significant effects? You've talked about what evidence does the applicant have that properties beyond that distance wouldn't be severely affected? You've just looked at guidance and added a little bit more, but you haven't looked beyond to see if there are any properties that would be significantly affected, and what evidence do you have that that's an adequate limit?
So if I could just be clear about the purpose of the RVAA, is not to identify all significant effects, and that's covered in the wider LVIA. So the purpose of the RVAA is to ascertain whether those effects are of such magnitude that the property would be widely regarded as an unattractive place in which to live. So that's the reason for limiting the study area to what it is. We don't say that there are no properties beyond this distance which would be significantly affected, but we don't believe that those significant effects would be such to trigger the threshold as it's defined in the LI guidance.
Okay, thanks. I'm going to ask you just one more question about the Landscape Institute guidance, and then I will come on to the Gillespie's guidance, Mr. Campbell, because I know you put that before us. So, bear with me. So that, yeah, it's going back to the same passage that Liz Bowen quoted from the Landscape Institute. And it talks about distance to, quote, the finalised route, not to the finalised tower locations. Is there an argument there in that wording that wherever you choose the threshold to be in terms of distance, that you measure that from the closest point of the conductors rather than the closest tower location, because it says route, not tower locations?
So the distance is measured from the centre line of the overhead line, not the closest point on the conductors. That's correct.
So, so the 170 metres threshold cut-off point, if you like. So, well, it's 225 and 270, but you're saying that's not in deciding what is included in the RVAA. That those distances were applied to the line at the closest point, not to the closest particular tower. Is that, am I understanding you right there?
Yes, that's correct. It's the centre line at the closest point.
So in effect, that means that some turbines, some properties will be included that are at slightly further distances, perhaps, to the nearest tower. In fact.
Yes, that's correct. So the distance to the nearest point of the centre line may be less than the distance to the tower, but would never be greater.
Yeah, fine. That helps, Mr. Wade.
Yes, could I point out that the assumption seems to be that the conductors follow a straight line from tower to tower, ignoring any deflection of the towers. If we have a situation where you have a particularly windy property, I live in such a situation, surrounded by wind turbines, that if there's a prevailing westerly wind, the typical deflection of the cable, which we don't know because there's nothing mentioning that in the EIA, but they don't always go in a straight line. They can deflect up or down according to temperature, and they can go side to side by wind, etc.
Okay, thank you.
Sorry, can I add to that as well? Going back, National Grid, in their Norwich to Tilbury application, have some very good drawings of that effect.
Well, they're not before us, so I'm not going to look at those. Okay. In Liz Bowen's report, in the same place, I don't think we have to go back to it though, but she's referring to the Gillespie's guidance that no teacup put before us. So that's document 022.023. Have you got that, Mr. Campbell? Yes, it's the reference is 022 0.023. Good question. So if we look at table 4.2, so it's at the top of page 8 on that document. It's in the executive summary, but it's fine. And so that table is called results of site-based assessments. And so you've got the last two rows are pylons, and then for pylons of 59 metres of height, it gives a distance of around 400 metres where it says a very large scale of visual impact might arise. And then if we look at table 5.1, which I think is on the next page, under section 5 is recommendations, and table 5.1 is titled Rough Guide to Residential Visual Amenity Assessment Trigger Distances for Wind Turbines and Pylons, and it seems to recommend a cut-off point for 60 metre tall pylons of 500 metres. So that seems to be in quite stark contrast to the guidance from the Landscape Institute, Mr Campbell, but the Landscape Institute guidance postdates it. So the contrast is clear. I don't need to ask you about that, I don't think, but we've separately held many wind farm public inquiries and appeals, and we've been referred to evidence, you know, for a great many others. I can't ever recall having been pointed to this Gillespie's document before. I don't know, and so my question was, Mr Campbell, have you ever seen this document used for the purposes that we're talking about today, if you have any knowledge of that? Your microphone, Mr Campbell, please.
It dates from 2014. Yes, there is an example, but I'm sorry, it's escaping me for the moment. But if you give me some time to come back.
Okay, so you're aware of it having been used
Yes.
in this kind of context?
I am aware of it having been used. It was in the borders, but I'm not sure which one.
Okay, and from the applicant's point of view,
Sorry, that's not very good. That's not very good evidence, but I will have a look and find it.
that's fine. I suppose I would say the same question from in terms of the applicant's professional team.
I may ask Mr Bell as well as Mr McRae to answer this from experience in other wind farms and other inquiries.
So I'm certainly aware of this document, but I'm not aware it's been used in this way, and I would, you know, again just reiterate that it predates the Landscape Institute guidance and doesn't make some of the connections between the findings and the way that reporters' decisions have gone, which are set out in the Landscape Institute guidance.
Just to answer from my experience, probably over 100 public inquiries or hearings in relation to wind energy around the UK, I haven't seen the document be used or referred to in evidence. Thank you.
Okay, thank you. Okay, if people are content, I was going to move on to the second part of item 3 in the agenda, so Roman numerals 2. And so this is called or entitled the residential visual amenity threshold and how any breaches of that feed into the overall assessment of effects. So this is about how we take this any conclusions on these matters into account. So if we can go back to the Landscape Institute guidance note, please. 022.018, if people haven't still got it up, and paragraph 4.18. I'm just going to have to read 2 or 3 passages, if you just bear with me, just till I get to my actual question. So, para 4.18 of that document, if people have it. So, just reading from the top of that paragraph, and it's talking about forming the final RVAA judgment, step 4, and it says there is an important distinction between this concluding step of RVAA and the preceding one. In step 3, the assessor has reached a conclusion with respect to magnitude and EIA significance of visual effect, and the change in visual amenity at the property. And the change in visual amenity at the property. In this final step, and only for those properties where the largest magnitude of effect has been identified, a further judgment is required. This concluding judgment should advise the decision maker whether the predicted effects on visual amenity and views at the property are such that it has reached the residential visual amenity threshold, and in my stress, therefore potentially becoming a matter of residential amenity. Okay? And then if you look at 5.2 in the document, which is under the summary and conclusions, page 15, the threshold at which a residential property's visual amenity becomes an issue of residential amenity has sometimes been described as the point when the effects of the development on the private interest is so great that it becomes a matter of public interest. The planning system only being concerned with the public interest. Now, so it seems to us you could construe that advice as being to the effect that if the threshold is not judged to be breached, and we know in this case the applicant's assessment at least is that it isn't breached, so you could take that as that advice is to be saying then in that scenario the visual effects on the property are purely an effect on private interest and not, therefore, since it says the planning system is only concerned with the public interest, a relevant consideration at all when determining this application. Now, on the face of it, that kind of interpretation to us seems rather stark, and it would in effect be saying that something is either relevant or irrelevant on the basis of professional judgment on the effect. It feels more natural to us to think of effects on residential visual amenity as always being capable of being relevant, since it's a component of overall residential amenity, but it's just that where the threshold is judged to be reached, then that becomes a consideration of greater weight in the overall balance because of the effect on living conditions. So, without necessarily poring over previous inquiry reports, I don't think we need to go there. I'll go to the applicant first. Is that your understanding of how one ought to take into account effects on residential visual amenity? Reaching the threshold doesn't turn it from being irrelevant into relevant. It just means that you have to put more weight on that effect in the overall balance. I don't know who from the applicant would want to respond to that.
I think in this form, sir, maybe ask Mr. Bell, but it also possibly be a matter for closing submissions, but Mr. Bell.
I think so, yes. I think that's a fair summary. I think the RVAA is used to establish where the visual impacts become so severe that, i.e. overwhelming or dominant impacts, where there's an effect on living conditions, not just a view. And that's not to say that significant effects that don't reach or approach that threshold are ignored in the planning balance, because there's a level of harm that is taken into account from a planning perspective. As you highlighted, the applicant's position is that there isn't a breach, and that reflects the overall routing and design approach that's been taken to the project, the success of that. But I think if it was determined by the decision maker that there are effects that are approaching or are a breach, then that is a matter that more weight would be placed onto, and that would be in the balance as well. I think if there's a situation where it's a very small number, then clearly that attracts potentially less weight from the decision maker, and all of the effects would go into the consideration of the policy tests, and I appreciate we're not covering that today, but just to say briefly, NPF4 Policy 11 does have reference to individual amenity effects on residential properties as well as settlement. And when all the impacts are considered together, there is a balancing provision there. And of course, routing an overhead line for over 100 kilometres, it will require a balance of interests to be considered in the routing strategy. So the decision maker would then go on to bring in the other considerations of nationally important essential infrastructure and so on. But that's how I would recommend the approach is taken to dealing with the spectrum of impacts that will come through in the RVAA.
Okay, thank you.
Excuse me.
So,
could I ask a question, please? Within our community council area, there are multiple properties where the residential visual amenity threshold has been breached. Wester Durris, Woodside, the house at Callendrum Wood, Meikledam Farm, Broomfield Steading Group, West Curley Cottage, and the hamlet of School Hill. So I'm interested to know at what point the individual private interest becomes public interest, because in our view, with those number of properties where the visual amenity threshold has been breached, we believe it is of public interest.
So I'm clear, that's you saying that they've been breached in that's your view that they're breached in those properties, not from the applicant's evidence, yeah.
It was from the Lisbon report.
I mean, to a certain extent, we're going to have to think about those issues, but I don't know whether the applicant's getting anything to respond.
No, I'd agree, so that is effectively what you, as part of this inquiry and your recommendation to the ministers, are having to decide, A, whether there has been a breach in any particular case, and then the consequences of that breach in the balancing of the applying policies and the recommendation to the ministers. That's really the question for the reporters, the factual and the consequences of that question.
Okay, thank you. So, I put forward a proposition. Broadly speaking, you agreed with that, Mr. Bell. I don't know whether, on behalf of No Teacup or Angus Council, sorry, Mr. Campbell, did somebody try and...
I would just say that in terms of the threshold, the RVAT threshold being reached, if you look at paragraph 4.21 of the Landscape Institute guidance on RVAA, it does suggest that field work should be more detailed at that final stage 4 to determine whether the threshold has been breached or not. It's not saying you have to do it, but it is suggesting that it might be a good idea to do it. You will see from my hearing statement, sirs, that I do consider that there would be a number of properties where I think the RVAT would be breached. But I did caveat that by saying that I have, like the RVAA, have only undertaken field work and observed those properties from the nearest publicly accessible point on a road or footpath. I have not visited the properties with the consent of the landowner and the property owner. I would have thought that with the significantly affected properties that have been identified in the RVAA, that those should have been subject to more detailed assessment, which should have included a more accurate field work or a more accurate visit to the property themselves.
And would you say that was standard practice or best practice for doing an exercise like this?
I think it does depend. I mean, I know with a lot of wind farm RVAA, it does depend on the landscape consultant involved. Quite often it also depends on the number of properties that you've got to assess. Now, this is a big job because of the 100-kilometre plus length of the line. It's a very big job to look at all of the residential properties that lie close to that line. And, you know, I don't know what the timescale was like for undertaking the assessment, but it certainly would be quite an onerous thing, considering how many significantly affected properties that have been concluded to be affected in the RVAA. You know, you'd have to get in touch with the owners and arrange access. I think certainly with some wind farm RVAAs, the individual properties are visited, and they'll make a judgment on more precise judgment on views from gardens, curtilage, also get a feeling for which rooms are principally used, for what purposes, etc. But I'm not saying that that is universal. I would say that that does depend on the landscape consultant and maybe the scope and timescale for the work.
Okay, thank you. It's maybe I'll maybe just before, because I might otherwise forget. I suppose if I just probably that's a good time just to ask the applicant if they can explain how they approached it and why they judged that was the most appropriate kind of approach here.
So just to be clear, is that the approach to how the assessment was done, the RVA was done?
I think it's more about, well, what I took more was about, yes, I think the first point Ms Anderson was making was about the thoroughness, if you like, or depth of assessment, but she was also posing the question, at least, about to what extent must you visit all the properties rather than at the closest accessible, point from the road network.
Yeah, so field work is, as you say, as Ms Anderson says, is recommended by the guidance, but it's not an absolute requirement. We've done field work from the closest publicly accessible locations to all the properties. We felt that was sufficient in terms of gaining an understanding of the setting of the properties and the general nature of views in and out. In my experience, that this is a typical approach that would be taken, not to do field work or not to do internal property inspections for every property, and as Ms Anderson has indicated, I think timescales and practicalities did clearly play a part in that decision. It's our experience that where there are properties in debate, as it were, that's the point at which the reporters typically prompt the requirement for internal inspections, and that's clearly what's happened. And we went to the properties last week that you'd identified as being necessary to visit.
Can I just add to that?
Well, I was just going
sorry.
to, I was just going to make a point of clarification. That's helpful, thanks. I mean, just I suppose, just for everyone's benefit, yes, we did visit some properties in response to requests that we do so. So I wouldn't say that necessarily means we won't think we might need to visit others at this point, but we've certainly done that to some properties. It might not be all of them. Ms. Joyner. Sorry.
Yes, I hope that you would agree that from the roadside, the impact from our home is not noted. We've been told repeatedly that the RVAA has been done from the roadside, but the avenue of beech trees completely screens our home and the impact of the line. So I think it's really quite important that if RVAAs are to be robustly completed, they ought to be done from the property, because I think from the roadside it is not clear in certain circumstances the impact of the line on households.
Okay, no, thank you.
If I may add as well, so, there will be a lot more evidence on this tomorrow. But if I am inferring right from what the applicant has just said, it beggars belief that they didn't have the time to come and visit individual properties that would be affected in such a project that has mammoth implications on this part of the world.
Yeah, okay, Mr. Campbell and then Mr. Wade.
The tool which the Landscape Institute has provided for this part of the assessment is a visual amenity tool. And it's intended, as I read it, to introduce a better degree of precision in respect of individual amenity than one can find from a more generalized landscape and visual impact assessment. I don't want to give you a history lesson, but the equation which gave rise to the technical guidance note was a case in Dover called Enniford Downs, which I'm sure you've had cited to you in wind farm inquiries from time to time. And in that case, the question was the same question about proximity. And the inspector said, when turbines are present in such number, size and proximity that they represent an unpleasantly overwhelming and unavoidable presence in main views from a house or garden, there is every likelihood that the property concerned would come to be widely regarded as an unattractive and thus unsatisfactory, but not necessarily uninhabitable, place in which to live. It is not in the public interest, and this comes back to your first point, it is not in the public interest to create such living conditions where they did not exist before. So the jump over from a private interest to a public interest is quintessentially a matter of judgment. Now, it's very striking in reading Mr. McRae's hearing statement that the applicants have not found a single instance in this line where the residential visual amenity threshold has been exceeded. Not a single instance, or over 300 pylons. And one only has to state that and recognize that this is a, as Mr. Wade has said, project of unique magnitude to wonder at the statement and to ask oneself the question, is it possible that this applicant has achieved a routing solution for the line which gives that result? But being a matter of judgment, and of course I respect Mr. McRae's judgment, there is room for alternative judgment, as we see from Elizabeth Bowman's report and the personal experiences of some of the people who've spoken this morning. So you have to be wary in my submission. You have to recognize that this is a tool which is designed to introduce greater precision, but it's not a tool which will give you a mathematical outcome because of the judgment that's required. You have to rely to some extent on what people say. Of course, they're self-interested. You have to rely on what landscape architects who bring their professional skill to the project, what they say as well. And you have to rely on your own observations, looking on site or from a house at the likely outcome of the development when constructed. Of course, you can't see it at the moment. And then make an assessment about the level of harm. None of us has a monopoly of wisdom on this question, and it is essentially a matter of judgment. You posed a question, what happens if there are impacts below the threshold which don't lead us to the Ennifer Downs conclusion, unattractive and unsatisfactory, but nevertheless are there as new impacts? Well, I like to think of this as a sort of basket of undesirable effects, which are not quite bad enough to trigger the threshold by itself, but nevertheless collectively may weigh or should weigh in the balance. And I think all of us would agree that it's a difficult job that you have to do in making this assessment because of the very magnitude of what is proposed. Where you're not sure, in my submission, you should be getting in touch with the owners, as you have done already in some instances, and trying to form your own opinion by going into their houses or asking them for permission to go into their houses and gardens and making that judgment. We rely, of course, on Liz Bowman's conclusions, but we're only one party in this inquiry, and I of course, accept that there is room for alternative views, but I'm finding it very hard applying what I think is quite rigorous professional judgment, finding it very hard to see how SSEN can come to this inquiry and say there is not a single instance where the RVAT would be exceeded. That's all I'd like to say at the moment.
I know, Mr. Wade, you want to come in. Mr. Warren's got a question, but Mr. Campbell, I was just going to ask you one question. I put the proposition to the applicant, and Mr. Bell responded, and if I'm paraphrasing really quickly, it was relevant even if as part of your basket below the threshold, but it comes with greater significance, greater importance, and greater weight, let's say, if one judges that the threshold's been met. But it then becomes a factor to put in the overall balance. I mean, are you agreeing with that broad proposition, or you quoted the Ennifer Downs and this notion of not being in the public interest, which is quite a stark way of putting it, which almost suggests that one failure to meet the threshold, if you could interpret that one way, meaning one failure to meet the threshold would mean that an application ought not to be consented, regardless of what other considerations come into view. You don't go as far as to take that kind of approach to the test, if you like.
Wouldn't kill off the application, because of course it's not the only factor in the scales. There are policy factors as well as other factors, agricultural factors, noise factors, ecology factors, biodiversity factors. All of these are matters which go into your scales, and this is only one of them. But it's an important one because ultimately the most important people in this room are those sitting mainly to my left who will have to live with the development when it's built. And therefore that's a factor that you have to put into play, you have to weigh in your overall judgment. But I'm not saying, sorry, I'm perhaps repeating myself, but I'm not saying it's an absolute yes or no because of one exceedance. Please don't think that. It is quintessentially, as I said already, a matter of judgment.
Okay, thank you. Sorry, Mr. Wade, you were waiting to come in.
Yes, thank you. I was going to repeat something that Mr. Campbell just actually covered himself, but basically my point was this concept of private effect and public effect. I live in the real world. I don't live in a world of desktop studies in Perth. To me, if somebody's sitting in a doctor's surgery waiting for a new prescription of antidepressants and a sick note because they can't do their job because they can't sleep at night, that is a public interest. That's my point.
Right, I take the point you make. Okay, sorry, you were going to ask a question.
Yeah, thanks. It's a question for the applicant, primarily, and it's probably Mr McRae, who's likely to be best placed to answer it. So, I'm interested as to whether there are any properties where you've found you've had difficulty making a judgment from a roadside, from kind of roadside fieldwork or desk-based fieldwork. Are there any particular properties where you've thought, actually, I'm not sure what the effect would be? And then, if that's the case, how's that been factored into the assessment that's before us?
I can't think of any specific examples of a property where that's been a challenge to the point where we wouldn't be confident in our assessment.
Have you had any properties where you've exercised more caution than you have where you have had, for example, a very clear view from the roadside, open fields behind? You might be able to make an assessment from the roadside very easily in that context. There are other properties which are down private tracks in amongst trees which are hard to see from our experience. So how's that been captured?
We've tried to avoid making assumptions about properties in that situation that would influence the judgment one way or another. So we've stuck to what we can understand from the site visit and from looking at aerial photos and so on and other available material. Okay.
And do you think that that's given you sufficient evidence in terms of the kind of principal outlook or outlooks from those properties where they are more difficult to see from the roadside?
To the extent that we rely on that in the RVA, yes.
We'll obviously form our own view about those matters and make decisions about which properties we feel we need to visit, as you said. So, okay, that's all I need. Thanks.
Okay, that's fine. I was going to move on then, if people were happy to do so, to the third Roman numerals 3 in agenda item 3, and this is how the use of microsighting informs an assessment of landscape and visual effects, particular effects on residential visual amenity. Now, actually, we've covered most of this already from the earlier discussions, but I do have one residual question, and it's just about how the conclusions in step 4 of the RVA have been informed by the restrictions on the limits of deviation, at least for some properties. And it's just it's probably just, you might describe it as a technical point, but it's maybe best to illustrate this by way of an example from the RVA. So if we can look, so that's document 001.288. So it's appendix 9.3 of the Environmental Impact Assessment Report, the RVA. And it's just by way of an example, without drawing any conclusions from the property I'm looking at. But I want to look at South Manecht Farm, if I'm pronouncing that right. It's on page 74 and 75. Let me just get it. Yeah, okay. So people got that. So if we just look at so the sixth column in the table, which is the second on the right, near the bottom of page 74, and it says here the horizontal limit of deviation has been restricted on the western side of the alignment at this location, limiting potential westerly movement of the alignment to 10 metres between towers N32 and N31. So it's a limitation on westerly movement. And then if we read from the same column, just going over the page, the top of page 75, this restriction, this is in order to maintain a separation between the alignment, my emphasis, alignment, and South Menecht Farm. And then if we go across the column 6, which is step 4, again, come back to the come back to the bottom of page 74 and then into 75, it says, furthermore, in supporting the assessment, there's no breach. The horizontal limit of deviation restriction would ensure that towers N31 and N32 could only be placed up to 10 metres closer to the property. Okay. We've got that statement about 10 metres closer. So if we then, I'm afraid we then need to look at the drawings, which are the overview of the variations of the limits of deviation, and so that's figure 3.3.22. So I think it's drawing 22 of those 29, where South Menecht Farm appears, I think.
Yeah, so that's document reference 001.027, because it's in two parts, that document.
So if people have that drawing, it's a plan with, it's got tower 90, N28 at the north, and it's got N44 at the south. You got that? So we can see South Menecht Farm here. It's near the top of the page. It's west of the alignment between towers N31 and N32. And it does indeed show that there's the pink operational variation on the limit of deviation, which wraps around South Menecht Farm. And it does show that the alignment can't move. Well, it says 10 metres, so let's take that as very close. So it shows that the alignment can't move very much to the west. But I'm not sure the statement that the towers can't move more than 10 metres closer to the house is factually correct, because if I look at it, it seems to me that N31, the tower to the north, could move southwards along the current alignment by up to 100 metres. That might not be likely, but it could, and still not breach that buffer zone. And likewise, N32 could move northwards by 55 metres. Well, either way, the tower could, it seems to me, move more than 10 metres closer, which is what it said it can't do in step 4. And this is an example. I think there's another example I saw that Upper Korsky, and I said I'm not making any point about the significance of that, but it's just I just want to be clear. I'm not implying that it would be breached here. It does look at least at some of the basis, at least as narrated in the final step, for that conclusion in step 4, doesn't seem to be factually accurate. I mean, am I reading that right there?
No, it's the alignment that wouldn't be able to move closer than the 10 metres.
Right. Yeah, the towers could move closer than 10 metres, but the RVA says they couldn't. I mean, that's my concern about, that's why I raise it. It seems to say something which isn't correct, and so I just wonder what implications does that have for our ability to rely on the ultimate assessment. No, I don't mean for this particular property, I just mean as a general point.
So, well, it's correct that the 10 metres applies to the alignment itself as a whole, not the specific towers. But I think with reference to what Callum was talking about earlier, there are clearly restrictions around moving tower N31 that would, that couldn't be done in a way that moved the whole alignment closer to the property.
Yeah, but it is the case that N32 or N31 could be moved more than 10 metres closer. Yeah. Okay. I don't know if anybody's got any comment on that particular issue. As I say, it's quite a technical one. I just wanted to get clarification on. Okay, I'll move on to next part under agenda item 3. So this is how the assessment takes into account effects on a property from multiple towers. Now this is a point raised by No Teacup, but not just by No Teacup, but just by way of illustration. I was going to refer briefly to Mr. Campbell's hearing statement. I don't think we have to go there. It's just one sentence I'm going to quote. It says, it's in the executive summary in section 4.1. It says surrounding effects, limited treatment in wirelines and RVAA. And as I said, other people make the point. But so I just want to be clear. So about the general points that, as I understand, people are making. So if you want to know the paragraph, it's section 4.1 of your executive summary, and it's the 5th issue down. But it's a wider point. That's in your hearing statement. Yeah. And we have elsewhere Liz Bowman in her report, and I think Ms Anderson makes a similar point, but Liz Bowman says the residential visual amenity assessment meets the guidance set out in the Landscape Institute technical note. But it's just a point about how this information presented. So the wire lines in each of the wire lines in the RVAA are based on a single field of view, and they're centred on the nearest tower, I think. So I guess, Mr. Campbell, thinking about what you and others, what you have said about this and what's in Liz Bowman's report, are you saying that there ought to have been more wire lines at each property so that you see the full horizontal spread of the possible view from each property represented in the wire lines? So, because presently, for many, the lines will go off page to the left and the right. Or, and I'm assuming you're talking mostly about effects on residential amenity. So is this a point? Is this a point about? I'm sorry.
Are you in the table at ES?
Well, I'm not anywhere in particular just now. The general point is that there is insufficient. The general point put to us is that there is insufficient regard. I think it's mostly about residential visual amenity assessment, right? That all we have is one wire line. For most properties, we have one wire line centred in the nearest tower, and the alignment goes off the page to the left and sometimes to the right. Okay, and so, and I think the general point being made is that there's insufficient treatment of the totality of the visual effects on a property. So, are you saying to us that the wire lines we should have multiple wire lines so that we can see that full extent, or is it a question of when you say insufficient kind of treatment of it, is it about the kind of narrative of how those effects are described?
I think the former. Fairness demands that the view which is being considered is set in its context. And one way of providing that context is to provide a wider spread of wire lines so that you can see left and right. Obviously, human vision is the angle of view is limited. We don't have 180-degree vision, but we all have peripheral vision. And this is a project which, all right, it doesn't move like a wind turbine, but nevertheless, the towers are very large. So what I think we're saying here is insufficient context for the views which are under review. Too many views in that sentence, but insufficient context.
Okay. Okay, sorry, I forgot to turn my microphone off there. Okay, so it's about the visual representation of the effects through the wire lines. And we've got, to be clear, we've got for most properties we have a single wire line. For some there are more provided. So I just wondered, I mean, this is a question about methodology, but I don't know if the applicants get any kind of comments on that criticism from some of the objectors. Can I ask the applicant to come back on this point, or was it about this point specifically? Did you want? Okay, well, no, on go.
In my view, SSEN have shown a total disregard for the residents affected. We will be able to see 6 massive pylons and overhead line from our property and from our site for sale with planning permission in principle. This will have a massive effect on our residential visual amenity, and SSEN have taken away our basic human right to enjoy our property and our right to sell our property.
I'll continue on behalf of my colleague. SSEN have taken away our basic human right to enjoy our property and our right to sell our property. They have ruined so many lives and businesses, and the impact on residential visual amenity has been massive.
Okay, thank you. So there's an example there. So yes, I'm going to come back to you, Mr. McKay, just on the kind of methodological point.
So, yeah, just in relation to the point about the wire lines, it's a tool in the assessment. The wire lines focus on the wire lines that have been presented. Focus on the closest property as being the one which is most likely to be considered overbearing, but it's not necessarily the case that we've simply ignored the other towers. You'll be able to read in the RVA assessment the references to other towers in different parts of the view, and we've obviously had access to visualizations from those views in writing the assessment, although they're not all comprehensively before you.
Sir, may I comment? May I comment?
Yeah, will you finish, Mr. McCready? Sorry. Yeah, yeah, okay.
I apologise, Mr. McRae, if I interrupted you. That's a really interesting point with regard to Kirkside of Lochte, and we will talk about it tomorrow. But the applicant has concentrated the wire lines and all the commentary on one tower, S111, which quite clearly they could see from or visualise from the road. They have commented in passing on tower S112, but they could not possibly have known what the effect was because they didn't go into the property and visit it. That's only my point.
Okay. I don't know if there's any other points on in terms of that kind of issue about the wire lines. No. Okay, so I'll just move on then to the last question I had, or last issue I had under number 3, and this is about the approach to assessing the effects on gardens and curtilage. So the RVAA talks about the angle of the direction of views from the elevations of each property, and I understand the basis for that, because from inside a room, the angle of view to the nearest tower will obviously be a relevant consideration when you're considering the effects, the visual effects from inside the property. But we noted that the RVAA sometimes talks about, well, it talks about views from gardens in properties as well as it does, as well as considering the effects from inside the house. I mean, it sometimes refers to an angle of view from a garden as being at the oblique. And I wasn't quite sure I understood the basis for that. It seems to us that from inside a garden, the particular angle of view might be far less an important consideration when considering the effects on visual immediacy than it would be from within the house. So I just wasn't clear on the basis for using that as a relevant consideration for effects from within gardens.
Yes, so I would agree that the use of the word oblique is intended primarily to refer to views from the house itself rather than from the garden, and perhaps should be interpreted in that way.
Okay, so where it says, where it uses that term for some properties from the garden, we shouldn't be taking much heedance of the angle of view. Yeah. Okay, that's fine. I answered the question. I don't think I need to ask anyone else about that.
Could I just be clear about that answer, make sure I understand it? Is Mr McRae saying that, I'm very sorry, it's my fault, I'm sure, but is Mr McRae saying that the angle of view from the garden is in some way undefined, less important than a view from the house?
Well, maybe if I can explain the basis of my question, I was surprised to see the description of a view from an angle from a garden described as oblique, because it didn't seem to be that relevant. If you're in your garden, you might be facing in any particular direction. You're not going to be facing out the direction of the window behind you. So obliqueness didn't seem to me to be particularly relevant, and I think. But the RVA does use the word oblique in describing several views from gardens, and I think Mr McRae said it shouldn't really be thought of as, that shouldn't really inform our judgments about views from gardens, obliqueness or otherwise. Is that a fair?
Yes, that's fair, and just to be clear, Mr Campbell, I'm not saying views from gardens are of less importance.
Okay, thank you very much. So that brings me to the end of item 3. So I think that's probably a good place to break for lunch now. It's just after 12:30, so I'm going to ask if we can be ready to start again at 1:30, please. Ms West.
I'm sorry, can I just ask one question, sir? The first agenda items, there has been no mention at all of the Rochdale principle, often called the Rochdale envelope, which has some of these flexibilities embedded in an actual application. So I'm a little bit confused about why that's not being taken into consideration, and there are so many flexibilities and uncertainties, because the Rochdale principle is a well-established principle, and it doesn't seem to be taken into consideration here.
Right, I'm not quite clear what you mean. What were you expecting?
I was expecting that the application would be much more assertive in what it is saying at this point. Because of the Rochdale principle, there still seems to be an awful lot of uncertainties and flexibilities in terms of limits of deviation. I think if you really look at the Rochdale envelope, there should be a lot more certainty in the application up for consent.
Okay, right, I understand the point you're making. Okay, if we need to come back to that this afternoon, we can do. But if everyone's content, then let's just close for now and come back at 1:30, please. Thank you.
Good afternoon, everyone. Welcome back. Afternoon. Right, it's 1:30, so we will make a start. I hope you had a good lunch break. Just to pick up Ms West's question, which she posed as we were breaking. Now, we have the conditions session on Friday, and we think that's going to be the more appropriate place to consider the overall parameters of any consent. You'll recall my question earlier, for example, about whether the consent should allow tower types to be changed from suspension towers to tension towers. So that issue is very much on our mind in terms of what the parameters of any consent would be. So it's not getting lost, it's just the focus here is very much on the scheme as proposed, as before us. Now, I'm just going to cover item 4 in the agenda because this too will feed into the condition session on Friday, so it seemed logical for me to pick this one up. It might be quite a brief agenda item, so it's focused on thinking about what, if any, landscape and visual mitigation measures could be provided for the overhead line for which consent is being sought. So we already have a lot of submissions and evidence about essentially the wider point that a greater mitigation would be potentially other route options or undergrounding, for example, or a combination of the two, but that's not for this session. So we're focusing on very much what landscape mitigation could potentially be delivered for the proposal in its current form. So there is a proposed condition which would deal with additional landscape planting. And I don't intend to look at the condition in any detail. It's more about the principles or the concept behind that condition. So we saw in the statement of agreed matters between Angus Council and the applicant that you essentially indicated that you expected this hearing to consider the commitment to additional landscape mitigation and enhancement measures within the operational corridor and any sort of wider mitigation and enhancement measures. So, as I say, I don't want to look at the condition itself, but just picking up on the statement of agreed matters, I suppose I would throw the question back to yourselves so you can tell us what is it that the applicant and Angus Council wanted or expected to cover today about the additional mitigation and enhancement measures. I'll perhaps start with the applicant, if I may. Sorry, with the council. Sorry.
So, sir, you mentioned additional mitigation, and that's what we're addressing in relation to your question. There are two types, broad types of additional mitigation. One within the operational corridor of the overhead line, and a lot of those measures are set out in the outline landscape mitigation design guide. Would you like the reference to that?
Yes.
It's 001.291 to 300. It's a number of documents. Our view of the mitigation measures outlined in that document, which are within the operational corridor of the line, is that they are aspirational. In fact, I think that is stated somewhere in the LVIA. There is no commitment to undertaking those measures. Those measures include things such as planting a shrubby undergrowth underneath the line that can cope with the operational requirements of the line, grading down woodland edges so they are a bit more softened, those sort of works. So there is no commitment to undertaking that, it being subject to landowner agreement, even within the operational corridor. The wider landscape and visual mitigation, primarily requested by ourselves, relates to both planting works, so tree lines, hedgerows, woodlands, but also includes adjustment of some towers, particularly near Lumley Den, and also towers that are prominent in views from significantly affected residential properties. We would like that to be considered too. And it seems from this morning's discussion that there seems to be some scope for movement of towers along the alignment. I think that was acknowledged by the applicant. In terms of the wider landscape mitigation measures, those are largely stated in section 11 of my hearing statement. And the council has been progressing discussions with the applicant on that as part of the landscaping condition, which I think was condition 25 in the draft conditions. We had got quite far on with that, and in my hearing statement, I had made a comment that the applicant had accepted the principle of undertaking wider off-site, if you like, landscape mitigation measures. But that seems to have dropped by, and there seems to be a change in stance now by the applicant since the issue of the note that I think was sent yesterday. And you will no doubt have seen the note yourselves, sirs. Essentially, the applicant now is taking a stance where they consider that no such wider mitigation, landscape mitigation measures are, I think they said, applicable or appropriate. And I think the gist being that they considered the embedded mitigation, i.e. essentially relates to the alignment and the routing of the line, is sufficient, and that the effects of the scheme are acceptable. I would say that we dispute this, and I think I would just turn your attention to Mr. McRae's hearing statement. Sorry, I don't have the reference number for that. But it would be paragraph 3.1.6. Mr. McRae, in his hearing statement, repeatedly notes against the topic of wider landscape mitigation that it cannot be committed to because landowner agreement would need to be obtained. It would be subject to landowner agreement. So that is quite often stated, particularly in section 9 of the hearing statement. What he doesn't specifically say is what beneficial effects would arise from such mitigation, this wider mitigation. But in paragraph 3.1.6, there is an indication in the last sentence of that paragraph where he says, in lowland areas, foreground vegetation and trees can also help to screen OHL infrastructure in all but the closest views. I would agree with that. And that is wider sort of planting that's helping to screen views and to mitigate the effects. It is a principle that I think is common to all large infrastructural projects, that you would undertake wider mitigation where you're able to help mitigate significant landscape and visual effects. I think there is an indication from the applicants that they don't believe that wider landscape and visual mitigation measures apply to something like an overhead line, high voltage overhead line. or any overhead line. I would say to you that I don't know of any specific examples where this has occurred in relation to overhead lines, but my experience is primarily limited to Scotland, and there haven't been that many since Beauly Denny that have been instigated. However, I would say that there are other sort of similar large-scale infrastructural projects where wider off-site mitigation planting has been undertaken, and to my knowledge it's been undertaken for the high-speed railways and also for some trunk roads. It's also undertaken for it was also undertaken for the Torness power station, for example. That was many years ago. And a point of interest, which maybe will come up in a bit more detail on Friday at the conditions session, is that in Aberdeenshire, I provide consultancy services to Aberdeenshire Council. We are working with SSEN at the Netherton Hub substation just outside Peterhead, and the principle of off-site wider landscape and visual mitigation planting has been accepted by them, and they've come up with, we have a condition to that effect, and they've come up with a plan which shows hedgerow planting, tree planting, which is off-site, intended to screen the development, which includes buildings up to about 29 metres, I think, from roads and settlement and footpaths.
Excuse me, that's helpful. So in terms of the communication which was sent to us either yesterday evening or this morning, I haven't had a chance to see, so that came through to us this morning and I've been preoccupied somewhat. So I haven't read that yet, so I do need to give some careful consideration to that before Friday. But there's some interesting points potentially coming out of that. So just for my own clarity now, does that affect what that proposed landscaping scheme condition would say? Do we know that?
Yes, our understanding is the applicant doesn't want any landscape condition, and we want one. And it not only will affect what what is discussed on Friday, but that will obviously be just dealing with the wording of the conditions. But the substantive benefits of the of landscaping, insofar as they're dealt with in Angus, will be something that Ms Anderson will hopefully be able to cover at an appropriate time tomorrow.
Thanks. So in a moment I will ask for the applicant's comments on that. Ms Anderson, I wonder if actually now would be a good opportunity to comment on kind of the potential substantive benefits of a wider landscaping scheme. I know that you've kind of touched on it. I suppose I'm interested in the extent to which, in your view, a off-site landscaping scheme can materially kind of mitigate the effects of a development of this nature. So if you've got any particular examples, you've cited a few there, but I'm interested in perhaps if there are particular representative viewpoints that you could refer us to. We don't necessarily need to look at them now, but just in terms of reference where we can think about, okay, what could be achieved here? What difference might that make?
I have identified some areas where off-site planting works would have some benefits. Particularly, this is in my hearing statement, sorry, I should say, section 11. I would say around the Emmock substation area, the Tealing area, you've got a very fragmented landscape character in that area, with existing overhead lines, substations, and then the new overhead line, the proposal we're considering today, plus the Emmock substation, all contributing to quite a cluttered and congested appearance of infrastructure in what is quite an open landscape. Now, there's, in terms of the existing substation there, there is some limited landscape works around it. There's some new planting, etc. I think that could have been a bit more substantial. But it's, in that area, as I mentioned, it is quite open. You've got quite large fields. You've got very few field boundaries, very few trees. And I think in terms of views from roads, but also from the dispersed residential properties you get in that area, if you planted tree lines, boundary trees along roads with hedgerows, thick hedgerows are really good at providing screening at car level view, but also people walking along roads. So it needs to be carefully thought out, and I would say in that particular area some sort of master plan needs to be thought about in terms of ameliorating what's there and trying to help screen some of the worst of the infrastructure. Can't entirely be screened, and it does depend on where your viewpoint is. If you're more elevated, you can't but avoid seeing it. But a well-treed landscape, as accepted in Mr. McRae's hearing statement, has more ability, a greater ability to screen and soften a large-scale development, infrastructural development. I would say another area would be the Jericho and Hayston area, where you've already got field boundary trees, quite a good structure of field boundary trees, but with gaps in certain areas, and that would provide a good framework to supplement that. And the line where it crosses the Sidlaws in that area is going to appear very, very large in relation to the scale of the landscape pattern in particular. You've got dry stone walls and in places less screening, so provision of trees and woodlands replicating the pattern of what's already in the wider basin area would be beneficial, in my view, in terms of views from roads, footpaths and settlement. Another area would be the Hochs. I don't know if I'm pronouncing this right. Cossons. Very open landscape. It is a large-scale landscape, and that, in some respects, lessens the impacts of a large-scale power line going across it. But in terms of visual effects, it is pretty open in places, and certainly with the landscape character descriptions that are in, for baseline landscape character descriptions in the LVIA, note the openness of that landscape and the fact that there has been quite a loss of hedgerow trees and hedgerows and woodlands in that landscape, probably through farming operations, fields get amalgamated, etc. But it is an open landscape, and if it were more treed, particularly sort of continuing trees, plugging gaps along some of the roads that crisscross that area and near the core path that goes across that area too, that would be beneficial in reducing the effects of the line. We'll be talking tomorrow about the South Esk Valley. That is sort of slightly different because it's a very narrow valley and the woodland is largely associated with the steep slopes of the valley, so it's more like riparian woodland, quite linear in pattern. There are opportunities in that area to provide additional woodland and trees on the shoulders of the valley, which would help because there's quite a lot of settlement, dispersed settlement in that area, which would be significantly affected. by the line. And then I think the Lochte, Mill of Crook area as well. It has some open areas, it has some existing woodlands, but I think a bit more integration there and screening would be beneficial. I think what I should also say is I'm talking about principally wider landscape and visual mitigation measures. So this is off the site, as it were. But I think attention also needs to be paid to the measures that are set out in the outline landscape mitigation design guide. They're very sound. They've done some good cross sections and all sound principles in terms of grading edges of woodland. And I think LUC are to be commended in terms of that approach, but there is no commitment to undertaking it. And it is aspirational. It's not accounted for in the LVIA findings, I accept that, but I think it's essential in terms of implementing additional mitigation. This line is very long. I think we're probably going to have a discussion maybe about whether it's a localised effect or not tomorrow, but you will know from my hearing statement, my evidence to this inquiry, that I don't think it is localised because of the length of the line. So that's the premise for my and the Council's stance, that we do need to see additional mitigation measures.
Thank you, that's helpful. If I can turn to the applicant, so it would be helpful to understand the applicant's current position, essentially, appreciating I haven't been able to read the email chain and the submissions that have come in overnight. Thanks.
Yeah. Thank you, sir. As you say, I think this will be the subject of further discussion on Friday, but there are a couple of different issues here. In particular, as Mrs. Hanson set out, the mitigation measures aren't accounted for in the LVI assessment, so the applicant's not relying on them in that sense to make the proposed development acceptable in planning terms. So at a high level, a condition, the position now is not necessary, but that doesn't mean that the applicant is not willing to consider the mitigation measures. The difficulty with off-site mitigation measures is, of course, that SSE doesn't control the land. So while we could discuss and maybe ask Mr. McRae to comment on the sorts of off-site mitigation that Ms. Sanson has been talking about, there's no control over that land. So if the landowners don't want it, then SSE cannot provide it. But that doesn't mean we're not willing to consider what could be done if those who are in control of the land wanted that to happen. It's a different matter, the on-line mitigation, which, as has been pointed out, consideration has been given to that in the appendix in the design guide. But again, there are potential difficulties with being able to implement that, and that's perhaps where the wording of any condition would require to be refined. But overall, the position is it's not necessary to make the proposal acceptable, although we accept it's desirable, and if there are buy-in from others, it is something that SSE would be prepared to take forward and to do. And in that sense, Mr. McRae can maybe comment on the sorts of types of mitigation that could be considered, but it's a different issue.
Thank you. Well, I will come to Mr. McRae in just a moment. I will come to others as well. There's lots of hands up, so I will come to you before Mr. McRae, actually. Just so I'm clear as well, though. So the condition 25 in the schedule of agreed conditions, those were agreed between the applicant and the councils. Is the condition that I was looking at yesterday no longer agreed?
Yeah, that's correct. It's going to be required to be considered further on Friday, with the applicant's prime position is that it's not necessary, and also that to look at the wording if something is to be imposed.
So did anything in particular happen in terms of the discussions from an agreed condition to become not agreed? I've got shrugs. Did the applicant simply kind of go through the condition schedule again and reflect on it and thought, actually, that was a step too far? I'm just not sure how, yeah. So my understanding was these have been worked up over a period of weeks and months, and we've taken a step back on this condition.
I think it's probably further consideration of whether it was deliverable.
Yeah, I understand. Mr. McRae, you're forewarned that I'll be coming back to you to pick up that other point. I'll just work around the table because I'm sorry I didn't see which order the hands appeared. So, Ms. West.
I'm not sure if this is the right time to bring this up, but because Ms Anderson did, I think great caution should be given to the weight of mitigation on planting by SSEN. A great example is the Sea Green substation. Back in the 1970s, what was Scottish Hydro then planted amazing lodgepole pine screening around the original substation, which was really effective. The Sea Green substation, which is 3 years into it, half the planting is now dead. There has been no maintenance. It's supposed to be maintained for 5+ years. In fact, the maintenance is so bad that branches are not only going up into the station, which means a lack of maintenance, they're going through the alarm wire lines, which means the alarms have not been maintained either. So that means that planting mitigation has not taken place. And I think it should be mentioned also that, of course, this does fit with the narrative, because the more that infrastructure is seen, it is more likely that more infrastructure like battery storage can come in, because it is already seen as an industrial infrastructure wasteland. So I just wanted to make that point as it came up from Ms Anderson.
Thank you. Yeah, and in terms of the enforceability question of kind of landscaping conditions, if there are any attached to any consent, that's something that we'll be thinking about in close detail on Friday as well. Mr. Campbell. Yeah, I will just work round.
If I may just refer you for your notes to Chapter 9 of Liz Bowman's report, which is headed Recommended Mitigation, slightly departing from Carol Anderson's more generic or generalised, and I don't mean any insult in that reproach. She's pretty specific about where she sees mitigation as being possible. She notes in 9.1 that mitigation doesn't focus on mitigation visual effects on residential properties, settlements or recreational users, which of course is our principal interest. And she goes on at 9.5 in a series of bullet points to specify possible mitigation proposals, some of which are on-site and some of which are off-site. She highlights the difficulty of off-site mitigation, but I hope it's not regarded as cynical. SSE have had quite a lot of time to get these ducks in a row so that they can propose actual mitigation off-site. And it doesn't really ring terribly true now if they come along and say, well, we might not be able to buy the land. They've had lots of time to do that. So I won't read the rest of that out. That's paragraphs chapter 9. There's a numerical error after 9.7. It reads 9.1, but it should be 9.8. And I'd invite you to look at that passage and take on board what she has to say in relation to more specific mitigation measures. I think Mr. Wade wants to go next.
Thank you. Mr. Wade, you might need a microphone passing carefully by the base.
Yes, sir. Thank you for the opportunity. Basically, it's the same thing as Mr. Campbell just mentioned. As I said earlier, I live in the real world, not the world of theoretical visions from laptops sitting in offices in Perth. The My personal opinion is the Scottish planning system is fundamentally flawed because of this obsession with conditions. As has already been mentioned, and I think it's going to be mentioned again, the system just doesn't work. SSEN have got an atrocious track record of failing to conform with planning conditions. We mentioned Bewley-Denny earlier. I was walking along the Bewley-Denny line a few weeks ago as part of a challenge walking across Scotland. I walked across a road, the old military road named after my great-great-granddaddy. Beautiful situation in Scotland between the, well, basically going down into Fort Augustus. You're walking along an old road that's part of the landscape. It was built out of the landscape in the 1700s. Very pleasant, snow-covered mountains to your left and woods, ancient woodland you're walking through. You get to the end there and you end up on the Bewley-Denny line. It is absolutely atrocious. Dried up peat that's just been left bulldozed to the side of the road and just left to rot. Drainage ditches that are full of rubbish. The whole thing is just a disaster. As I say, SSEN have got a terrible track record of conforming with planning conditions because there's no sanction, there's no policing. There's disputes about the Bewley-Denny that have been going on for decades now about who's responsible. Is it the Cairngorms National Park Authority? Is it Perthshire? Is it the Scottish Government? Nobody agrees. Meantime, there's tracks, just scars across the landscape at Dromocta Summit, you know, where thousands and thousands and millions of tourists are doing every day to look at the beauty of Scotland. SSEN cannot even recover the ground that they destroyed then. So, yeah, the system just doesn't work.
I understand the point you make very well, Mr. Wade. I mean, in terms of other schemes and the success or otherwise of them, that's obviously not something we'll be considering. What we will be considering very carefully is the enforceability of conditions. We will talk about that again on Friday. So I shall have to look around and just wave if you're wishing to speak. Yeah, thank you.
Hello. I would like to raise the issue of monitoring and management as well, because without that, there is no way to say that this mitigation is going to reach fruition. We need more details about the length of time for trees to reach maturity. I'll echo what Eileen said earlier on regarding Emmet substation. The original substation at Tealing was well screened. Then along came Seagreen substation and half the screening was taken down. The screening that was put up for the next substation, the Seagreen one, wasn't, as Ms West says, it wasn't monitored. The saplings were small saplings. They reached the top of the protective covering. Once they'd reached the top of the protective covering, the deer ate them. There was no replanting to assess that, but even if there had, you've then got to take in the allowance for that amount, for that sapling to then reach the same height as the other ones. So the whole time, this continual time taken to reach what you're aiming to achieve is taking longer and longer, and without that, it is simply, it's just a nice idea. It's not actual monitoring and management of the situation. We also have to take in part, if they took down some of the screening for Seagreen, in the future, should this go ahead, then the screening that's put up potentially may then be taken down to accommodate future development there. So the whole time, you're putting up screening, but it's attracting more development, and the screening is then inadequate, and there's nothing in there to stop that happening. We've mentioned a lot today about how the mitigation was put in place in respect to the plans that have been put in. We've spoken about limits of deviation. There's nothing in the mitigation to accommodate this increased height of the potential towers. There's nothing in it to accommodate the work that's going on at the moment for road widening, for example. That changes the landscape. So the initial mitigation that's putting in is not reflecting what the current situation is, or potentially what the future plans might be. I would like to say that off-site, I understand about off-site mitigation. However, That doesn't affect individual residents, and that's when we come back to our MPF4 policies regarding local living, and especially policy 29 regarding rural development. This is the rural development, this is the rural area that is being affected, and yet you are planting somewhere else, which potentially doesn't help your locality. And it all comes back to that definition of locality, which has been raised a number of times by Mr. Campbell and others this week. Hang on, I don't say I'm writing things furiously. Can I just also say that alternative technologies have never been investigated. Now, the Electricity Act Schedule 9 says that it has to show that you need to do what you reasonably can to make sure the impacts aren't as big as they are. However, that has never been addressed. That potential mitigation has never been addressed. So potentially the impacts from these overhead lines has never been addressed, and it could have been less visually and landscape-wise should alternative technologies have been addressed. And again, with policy 11 as well, that should have been looked at, and it hasn't. So that impacts surely on the landscape and visual and the mitigation, please.
Thank you. Yeah, well, for the purposes of this session, we won't get into
okay, I understand that.
And, yeah, that's absolutely
Fully
fine.
Understand
but I do take the point, though. So yeah, thank you. I shall look down the road. Yeah, thank you.
Thank you. Thank you. The applicant has accepted that there are significant landscape and visual effects. So it strikes me that mitigation is an important part of the decision-making process. And it strikes me as well that the mitigation has a stronger weight if it's certain and secure than if it's depending on future agreements or implementation that are uncertain. So I really hope that you will take that into account into your decision-making. And the second point I want to make, you've talked several times about an updated conditions statement or agreement. As community councils here will be participating in the hearing on Friday, but we haven't seen any update to the conditions, so we'd really appreciate being forwarded that, please.
Yeah, that's a very, very fair point. I have instructed the office to circulate it to all participants, so hopefully by the time you get home and you're ready for some bedtime reading, it will be with you. So,
thank you.
Yeah, sorry about that. Yes, thank you.
Thank you. Just in terms of the landscape and visual effects, I'd like to draw the reporter's attention to the Dee Valley Special Landscape Area. And then I quote from SSEN's EIA, Volume 2, Chapter 9, Landscape and Visual Amenity. And if we go to page 70, it refers to the River South Esk LLA and the Dee Valley SLA. Well, the Dee Valley SLA is in our patch. The assessment says that the significance to the Dee Valley is major. The visual impact is major, brackets significant. And the additional mitigation it suggests is softening of forestry and woodland edges. Incidentally, that's the same mitigation for every single predicted effect. And the softening of forestry and woodland edges is then supposed to take the visual impact to, it remains, the residual effect following additional mitigation is still major, brackets significant, and yet the cumulative effect is not significant. So there's a couple of things in there. I don't personally understand how post-mitigation the effect is still major, brackets significant, and yet the cumulative effect becomes not significant. I also don't understand how, if the mitigation is going to take place off-site, is going to mitigate the impact in the Dee Valley SLA. And then the other point I wanted to make about this was where the pylon line is proposed to cross the River Dee is mainly open arable land. So how softening of forestry and woodland edges is going to reduce the visual impact of the pylon line crossing the River Dee is is a mystery unless, of course, SSCN buy up the neighbouring farms and then plant trees on them. Even if they do that, your average oak tree only grows to 40 metres. This pylon line will be in excess of 60 metres where it crosses the River Dee. So in that sense, the screening really is going to have minimal impact for the local residents.
Thank you. And we may well come back to the River Dee SLA later. I'd like to turn to Mr McRae, please. I mean, you've heard a lot there, so I appreciate, do take your time in terms of responding to what you've heard. I'd like to hear kind of your view on the value or otherwise of kind of off-site planting and landscaping, notwithstanding the fact there might be challenges in delivering that or securing that, and the appropriateness of conditions can be discussed. So it is caveated with that, so you're not landing yourself in bother with your clients. But if I could have your kind of clear view on that, and then any reflections that you have of what you've heard around the room, and then we'll perhaps pause and we can come back to the question of what can be achieved within the application boundary envelope, essentially, in terms of planting within that, where you do have that control.
Thank you. If I can start by saying that, yes, I generally agree with Ms Anderson's summary of the benefits of mitigation planting. I mean, as a landscape architect, in general, I'm in favour of trees. I'm in favour of measures which enhance landscape character. I think there would be benefits to the wider landscape from measures that were off-site. I would only caveat that by saying that it's not possible to screen every view of an overhead line in the way that it might be perhaps easier to do for a trunk road or a railway line or similar projects. So I think there is the same principle does apply to overhead lines, but I think there is a difference in terms of what the available land actually means for overhead lines. But I do agree that there is a benefit to having a wider landscape planting where that's feasible and it's possible to do that. I think just picking up on a few points that I jotted down, I accept that any tree planting does take time to reach maturity, and that needs to be given consideration. As Mr. Burnett said, the applicant is still committed to exploring the potential to do wider mitigation, and I think it's reasonable to say at this point that we'd be happy to take on board the suggestions that have been made by Ms Anderson and Ms Bowman and others in formulating those proposals subject to the caveats which you've heard. I think that's probably all I can respond on, unless there was anything else in there that you feel I need to give an answer to.
No, I don't. I think so. In terms of what can be achieved in essentially beneath a line or within that wider corridor that comes with a proposal such as this, what benefits or mitigation, if any, does that can that provide? Albeit it's at obviously much closer range than a potential wider landscaping scheme.
Yeah, of course. So the outline design guide, which is Appendix 9.6 in the ES, is I guess it's focused primarily on best practice restoration. It would be fair to say. So trying to put back what's been taken away well, not putting back what's been taken away, but replacing it with something that's, you know, not the worst that it could be, but going about that in a responsible way, and that's what that's sort of directed towards. It's not really feasible to deliver mitigation for visual effects within that area, and we accept that that's the case.
Thank you. Ms West.
Sorry if I missed it. I didn't hear any explanation of why sea green has not been maintained according to the conditions put in place at the time.
Yeah, Ms West, I won't ask the applicant to respond to that because it is a different scheme, it is a different proposal. It's not a matter which I want to spend time on now. Mr Grant.
It was also to clarify, it's not our application, it's not our infrastructure, and the consent doesn't sit with us.
That's as good a reason as any to not ask you. Mr Finlay.
So I just want to come back on the points we heard from the applicant. And I know you've got the point. I want to make three short points. First is that we're concerned with the lack of commitment both to off-site mitigation and on-site mitigation. Secondly, as I'm afraid Mr Burnett said, it may be desirable, but it's not necessary. That's the applicant's view, and it's clearly not the view that's shared around the table. It'll be a matter for you to judge. But in our submission, if it does become necessary, there's no impediment to producing it because CPO powers will be available. And whilst Ms Anderson may have been talking about a number of site-specific locations, as have others, for roads and railway lines such as HS2, which I have some experience of, there's no difference in terms of long linear developments and having off-site mitigation secured that's dependent upon CPOing the land in question. If that position is in dispute, then that would be helpful to know that in advance of Friday. And finally, just to pick up the point that we're not seeking to screen every view, we're looking to ameliorate the impact as best as can be done, both in terms of more larger scale landscapes, but also in terms of individual dwellings. Thank you.
Thank you, Mr Finlay. I'll just look to the applicants, just see if there are any final comments, and I'm going to move us on then.
Not at the moment, so I think we'll move it on until Friday.
Great. Yeah, thank you. Yeah, we will indeed be looking at this in perhaps somewhat more detail than I'd anticipated on Friday, so we will pick that up then. Apologies.
Sorry, very quickly, can I just point out that CPOs are happening just now regarding roads, so trees are being felled as we speak. Thank you.
Thank you.
Okay, thank you. I'll move on to the next agenda item. I just had one point of clarification I was going to ask for Ms Anderson. When asked, you suggested a list of locations where you think there might be benefit in wider planting. Those were all in Angus. So you're working for Angus today. So I'm not asking you to provide a list of similar places in Aberdeenshire, but there might have been one. You're not saying those apply, those are the priorities across the whole of the length of the line. It's just that you've addressed yourself to effects in Angus. Am I right about that?
That's correct, sir. I'm representing Angus today, but you may be aware that I did do the landscape and visual appraisal of the route as it is aligned through Aberdeenshire. And I can't recall quite what I mentioned in terms of mitigation, but I'm certain that off-site mitigation was part of that. And I can certainly provide you with a bit more information on that tomorrow, if that's okay, because I'm not prepared today, I'm afraid.
Yeah, no, that's absolutely fine. I just wanted to be clear about the scope of what you were telling us about today.
Okay, yes.
Yeah. Okay, let's move on to item 5 then, which shouldn't take too long. And this was unaccompanied site inspections to other overhead lines. So obviously we've been very conscious doing our site inspections. There are other overhead lines in the wider area. And so I suppose there was two parts to this. The first part, and maybe taking a cue from what you said, Mr. Wade, maybe the answer is no to this, but the first question was, are there any other towers of comparable height elsewhere in Scotland and the UK that you know, people might point us to go and have a look at, so as we can get an appreciation of the type of size of towers. Maybe there are none, and that's something people could tell us about just now, or it's something that you'd want to reflect on and maybe put it in writing to us, maybe in a week's time or something like that. I don't think it's necessarily information which we have to ask other parties to comment on. It's just simply a factual level of information. But I don't know if you've had a chance to think about that. I'll ask the applicant first of all.
Yeah, so what we've been able to do is we've got the tower schedules, which list out the towers and their locations and their heights for the existing infrastructure in this area. So that includes Kintore, Fetteray, so down to Ailith, Tealing to Ailith, and Tealing to Westfield. And we've also got the southern section of Beauly Denny, which is more akin to the sort of landscape that we have in Angus, and we've got similar for that. So the tower schedule, we've also got a numbered map, so you can correlate the tower number to its location and its height. And we can also provide a selection of towers that are of similar height for you to go and visit, and provide you that in writing. The southern section of Beauly Denny that we've got averages 55.4 metres.
Okay, thanks. I mean, that sounds very helpful. I don't know if there's any other people have any other examples of other larger projects elsewhere. Okay, Mr.
Yeah, sorry, as I mentioned earlier, can I also emphasise, because there's an awful tendency to talk about tower height. We have to remember we're talking about a square rule. You know, for every metre that the tower's higher, it has to be a certain number of metres wider, and it's a square format, so the area occupied is the square of that increase. So just saying by something is a comparable height doesn't mean to say it's got the same visual impact. You know, the terminating towers, as I mentioned earlier, are enormous, not just because they're higher, but because of the volume of steel that they're occupying on the landscape. So if you want to talk about comparable towers, you have to remember this AS4 design is a whole new design. It's based, the way I believe it's based on the Beauly Denny design, but it's not the Beauly Denny design. It's a bigger version. So, you know, you've got to compare apples with apples and not say, oh, it's a 55 metre tower or it's a 25 metre tower. Think the square rule. Thank you.
Okay, yeah, and I understand the health warning you put in that. Okay, so Ms Anderson, I think it was in your hearing statement where you did happen to refer to the existing Ailith to Tealing line and the average heights of that, and then I think it was yesterday Angus Council provided us with some further information on this as well. So certainly given, if you're going to give us some comprehensive information, Mr Grant, that probably sounds like that would be sufficient for us, and if you can maybe just copy in the other parties when you're sending us that, or ask us to put it on Objective Connect one way or the other, just so that other people can at least see what we've been directed to. So that probably covers that issue, unless there's any other comments, Mr Wade.
Sorry to come back and keep interrupting. A good part of the proposed line, particularly around the Fetteresso Forest area and north of the Hurley substation, the plan is to have the existing Kintore to Ailith line running in close proximity and parallel to the new line. Since there will be a disparity in the size of the pylons and the design of the pylons between the two lines, is that not a landscape issue about the disparity causing a cluster effect or a cumulative effect. I don't know what the terminology is in the landscape world, but the disparity will actually increase the clustering effect, to use layman's terms.
Okay, so you're asking us to take that effect into account? Yeah. Okay, let's move on then to item 6 on the agenda. And we'd put together sections F and E. So section F of the line north of the River Dee to Kintore, and section E, the Hurley substation to River Dee. It felt easier to run these together just because, thinking about the landscape effects, the River Dee is not necessarily a helpful boundary marker, if you like, in terms of we think about landscape effects in the round. And my apologies to Ecton Skene Community Council for initially putting you in the wrong place in that agenda, so we'll come to you first. So I was just going to repeat that actually for a lot of these items, when we now go through evidence from individual parties and a couple of things about individual receptors, for the most part we're pretty clear about what people are telling us, so I don't have a lot of questions to ask in the same way that we did this morning and just there. But I do want to give you the chance to say what you think you need to, in addition to your hearing statement, or indeed to respond to what the applicant said. So in terms of the evidence from Ecton Skene, which we think we'll just come to first, I think you do understand what you were saying. I note the point you made about limits of deviation. We should be coming to that on Friday, so I don't think we need to get into that today. So it's just an open question to you, particularly having seen what the applicant's hearing statement was, having heard the evidence this morning. Is there anything that you want to draw out from your hearing statement that you submitted? I mean, I should say it's fine if there isn't. That's not. Don't take that as a challenge. I'm simply not asking you because I'm really clear about what you're saying. I just want to make that point.
So the only thing I did want to, it was very helpful actually this morning, your in-depth interrogation about limits of deviation and highlighting the fact that the landscape, or rather the assessment of residential visual amenity in the light of LOD changes to towers locations has not actually been properly covered in the EIA, and Southman Act is a particular, I think, case in point, but it applies to other locations particularly where properties are close to angle towers, and those angle towers can be moved much closer to, or could be moved much closer to residential properties and their curtilages as a result of the very wide, can I say, laxity of the LOD requests which the applicant has proposed. And it's not clear to me how the planning authorities would be able to assess those effects and whether they would have any ability whatsoever to actually say no to a request to relocate a tower much closer to a residential property? Because it's not clear to me what their rights are to deny such requests.
Are you attending the Friday session on conditions?
Yes, I'll be there as well. Yeah.
I mean, that is probably a discussion we could have on Friday, because there's a lot going on in that condition that's probably bears us talking about. Okay, so that's helpful. Thank you. In terms of the evidence from Echton Skene Community Council, is there anything the applicant wanted to say? Obviously, you've had the chance to see their hearing statement and discussion today.
So I don't think there's anything specific on that statement.
Okay. I'll move on to the evidence from Bankery Community Council, if that's okay. I do have a question to ask first, and then I'll maybe give you the opportunity for the kind of wider point if you want to make them. I'll just read out a little bit from the statement, from your hearing statement. So, cumulative impact, it says, is Bankery Community Council's greatest concern. The proposed overhead line does not exist in isolation. Communities are already experiencing the effects of transmission upgrades, wind energy developments, substations and other major infrastructure projects. And we've got lots of evidence from people, both in terms of cumulative effects, both where they are, but making a more general point. But I suppose I'm thinking about, for the Bankery area in particular, can you tell us which other projects give rise to the greatest concerns for you in terms of community effects, in terms of cumulative effects?
Yes, I can. Currently, there's a large wind farm being proposed on the Hill of Fare, which is to the north of Bankery. That includes a battery installation and will eventually include pylons. To the south of Bankery, there's a Glenskinnen Energy Park being proposed, which is a wind farm, a solar farm, battery installations, and will also include pylons. The Glendye wind farm to the south of Bankery has just been approved, as well as pylons going over the Cairner Mount, which is an area of outstanding beauty. And that's what we know at the moment. So it's just flooding us out.
Okay, and the first two, Hill of Fare and Glenskinnen, was it? They're both current applications,
correct.
But Glendye has now been consented.
Correct.
Thank you, sir. The Hill of Fare was subject to a Section 36 application. It's been through inquiry and that's awaiting. The Glenskinnen proposal has not got as far as application stage yet.
Okay, so that's at scoping stage or something like that, is it? Yeah. But I take the point, it's a project that's in the offing, maybe. Okay, thank you, that's helpful. Okay, so I suppose I would just ask the same general question I did then, having heard what you've heard. Is there anything else you want to kind of come back on?
Yes, I did. My submission was more a general statement of what it feels like to live, work and visit this landscape. It wasn't technical in any sense whatsoever. Yes, it wasn't technical in any sense whatsoever. But I would like to concentrate a little bit of my questions on the River Dee crossing specifically and the Dee Valley Special Landscape Area. The River Dee Valley the crossing is one of the most sensitive locations on the route. And you have accepted that the significant effects occur, and it's not clear what the mitigations are, as my colleague here has already spelt out. So I have, actually, if it's okay, I have 3 questions for the applicant and 1 for the reporters, if I may. Thank you. So for the applicant, why are significant effects considered acceptable in this location? And how do you distinguish this location from where impacts become unacceptable? That's my first question.
I mean, I suppose ultimately, well, not as ministers would be the arbiter of what's acceptable or not, but I don't know if, in terms of what the applicants put forward, I don't know if you've any response to that question.
Sorry, can I maybe just respond briefly on that? I think the applicant's position would be that there's an inevitability with large-scale infrastructure and development projects that there will be some significant effects. They don't necessarily need to be landscape and visual, although often they are. But there's a long-standing planning principle that significant effects are not automatically unacceptable. And planning policy tells us in National Planning Framework 4 that in particular for electricity projects, there's likely to be some significant effect arising. So the question then for the planners involved, whether that's planning authority, reporters or advisors to developers, is can you get a project designed and cited and developed such that there's no unacceptable effect, and that's a planning judgment, and it links to what the reporters were saying this morning about, and Mr Campbell, about a planning judgment required, whether it's a new industrial development or a housing development or an overhead line. You know, there will be some significant effects, but it's differentiating between those that cause serious harm such that they're unacceptable, and then those that are mitigated or are acceptable in themselves.
Kind of unacceptable to who, but I'll move on. So my second question is, what specific mitigation is proposed for this very sensitive River Dee crossing?
Again, I can turn to the applicant to respond. One thing I was going to say about the agenda, and this is absolutely fine, I'd put effects on the Dee Valley Special Landscape Area as a kind of as another item in the agenda. But obviously, it's relevant to you, it's relevant to Cathis, to Moke and Durras as well. So it's fine. We just deal with it in this way. No, absolutely not. I wasn't sure what the best way to do was anyway. So yes. So again, I'll maybe just pass over to the applicant if they've got any response to that point.
I think the mitigation measures that are possible are considered in the EIA. The actual D crossing was something that was chosen with some care. It's unfortunately 2 linear projects. You have to cross the D at some point, and I think that was certainly taken into account. But the applicant does recognise that there are significant effects, and doing it there, as there would be in most places where you cross the Dee.
So my third question, if I may, sorry.
Can I just come back, because actually we had a question about this, and it's probably a good time just to pick up on that, if I may, before I come back to you. I was going to ask how you went about that process. You said you're aware of the effects in the Dee, so I suppose the question I was going to ask is, how did you have regard to the existence of the special landscape area or the effects in the Dee Valley more generally, and how has the alignment responded to the presence of the valley landscape and the special landscape area? And I've got a follow-up, but I would just maybe if I can put that point first.
So I'll try and respond to that point. As Alistair's referred to, the linear nature of the project means that the river needs to be crossed at some point. In the consideration of routing and alignment options, a number of alternatives were considered. As part of that, obviously the landscape constraints formed one of the environmental criteria that were considered when comparing options. The presence of the special landscape area obviously denotes a sensitivity to that location. The SLA would have been crossed by either of the options that were considered, both at the routing and alignment stages. I think it's acknowledged in the documentation that the crossing that was settled on, the one that is the preferred route, preferred alignment, does cross the SLA where it's slightly wider. However, that was chosen on balance in respect of a series of environmental and technical constraints that inform the decision to take the alignment slightly to the west of the one that was originally considered. So in a sense, that question about mitigation, that embedded mitigation, begins with the consideration of routes in the first place and seeking to achieve, on balance, route options that were less constrained overall.
Thank you. And just a point within that, because it's raised in the evidence, can you tell us about how the loss of woodland might have been factored into that approach? And well, I could have a look, but if we see the photomontages, does that show any loss of woodland? Has that been rendered into the photomontages, or is that not showing those? I just can't. I'd have to go back and check, but I just can't remember. So yeah, how was the woodland factored in, and do we see that in the photomontages?
I'll take the first part of that question, if I may, sir, and pass it in a second one to Paul. In a similar respect to my previous response, the loss of woodland from any of the routing options was a key criteria, both as part of the landscape character appraisals and in respect of other criteria, including the ecological considerations and indeed any that were part of a protected site. So woodland sort of spans a number of environmental criteria that the routing process considered. So partly landscape, partly ecological, and where of a commercial nature, partly in respect of commercial forestry.
Yeah, just to follow up on your question about the visualizations. So I've just found the reference within Chapter 9, which is the LVIA, which is paragraph 9.329, which does say that areas of infrastructure and management felling have been modelled into visualizations where it would be clearly visible.
I'll just check that. Was that a slight caveat at the end, though, to where it would be clearly visible? Have there been somewhere it would be potentially partially visible, so it hasn't been included? I know it's slightly splitting hairs, but
I think it's where it would be visible and would contribute to the impacts. It's been included in the visualization, but where if it's a distant area that might be visible, but is going to be distant and not necessarily contributing.
Okay, thank you. I do beg your pardon, I interjected there. Back to number 3.
Yeah. So you mentioned just then a little bit, actually, and my third question was what alternatives have been fully explored? I'm not an engineer, but I wonder if lowering the towers or going underground would be some of the options that perhaps you've looked into.
The alternatives considered were really, as Henry outlined already, in terms of the...
Speaking very fast and it's difficult to understand what you're saying, sorry.
The alternatives considered for crossing the D were, as Henry had set out, were both at the routing and alignment stage. Is that working? Can you hear me now? So the alternatives that were considered for crossing the Dee Valley were, as Henry had set out earlier, were considered part of the routing and the alignment stage appraisals.
So that was the...
Sorry.
So no other alternatives, basically.
Sorry, were you going to say more, or are you finished up? Apologies, I wasn't sure.
No, I was just going to confirm that no other alternatives were considered. It's not obvious how lowering towers would have ultimately achieved the crossing, but no other alternatives were considered.
So, based on what Mr. Collins said, he referred to two alignment options, one which is further to the east and one, the westernmost one, which is what was selected. So those are the two alternatives that were considered, just to be clear. Yeah. You said you had a question for us.
I did. In our community statement, Banbury Community Council expressed very clearly that we're fighting for our economic life. You know, the oil and gas industry is downsizing, and we're looking to tourism to be our main source of employment. So how will the special qualities of the Dee Valley SLA and the consequent socioeconomic impact, I know we're in landscape and visual today, but they come together, how will they be weighed in the planning decision?
So it was the special qualities of the landscape.
The SLA, and associated with that is why it's so important to us, is the impact on tourism. How will they be weighed?
I suppose the very unsatisfactory answer for you at the moment is we're not sure, because we you know, we're not at that stage yet. We're listening to evidence. The stage of then coming to synthesise that just hasn't really started yet. So that's not a deliberately evasive answer. I just don't know what the answer is to that yet.
Thank you. Thank you very much.
Okay. Okay. Did you think no? I'm going to come on now to the evidence from Crathes, Stramoke and Durras Community Council. A couple of questions. Well, one thing I wanted to clarify with you first. In your statement, you refer to the applicant's evidence ignoring the nighttime effects from aviation lighting. Now, my understanding is there isn't any aviation lighting proposed for the towers. I just want to check that's correct, isn't it?
That is correct.
So I just thought worthwhile as a point of clarification. But for the Community Council, I was going to ask you the same question as I asked of Banbury. You again refer to cumulative effects. What projects in particular would you highlight for us as being the most concerning or the most important for us to take into account?
Sorry, I'm not entirely sure we're looking at the same document here, because I'm not aware that we did refer to aviation effects in our, it's a teacup line landscape and visual effects, CDDCC.
Bear with me a second, I'll just see where I might have picked.
Unless, of course, I've missed it. I beg your pardon. I beg your pardon. Absolutely spot on. Yes. Yeah. So you asked about the cumulative effects. Yes. As my colleagues already said, we have the Hill of Fair wind farm. We have Glendye wind farm. We have the Glenskinnen Energy Park, which is proposed for the hill south of Banbury. There are multiple offshore wind farms which are proposed to come on shore in the Stonehaven area, where pylons will come over land to the proposed Hurley substation. So there are many, many out there. And I think the point we like to make as community councils is we are volunteers with lives, and we are really pushing water uphill, trying to give an input to all the proposals that are out there.
Yeah, no, that's fine, and I get the general point. I just wanted to make sure I was clear about what particular projects for the community council that you would highlight. Okay, I was going to move on then. We've started to cover it.
I'm sorry. I've got quite a lot more to say. Is that okay? So yes, apologies. It's a while since we wrote this, so I did miss the bit about the aviation lighting. But I want to raise the Horlock Rules guidance, which I quote in the statement, that areas of local amenity value, important existing habitats and landscape features, including ancient woodland, historic hedgerows, surface and groundwater sources, and nature conservation areas should be protected as far as reasonably practical. So there's quite a lot going on in Dee Valley. We know it's a special landscape area. There is the Loch of Park SSI, which is directly adjacent to the line. It's not a few hundred metres away. It is absolutely on the edge of the corridor. And it is a SSI, and clearly the impact of 50, 60 metre pylons adjacent to that is pretty significant. If I come back to the Dee Valley itself, the Dee crossing, there is an existing piling line that crosses the Dee in the proximity of this proposal, and that line would require to be moved a few metres to the west. Now, in the moving of the existing line, the pylon line becomes, it zigzags, which means the towers will be tension towers, and we've already heard how they are heavier and more visually impactful. So there will be 5 existing towers to be moved, or maybe more actually, maybe about 7 to be moved. And then the new proposal, the pylon towers are virtually all tension towers again. There's 6 of them as they approach the River Dee. So again, there'll be very significant towers. They are 60 metres high plus 9 metres vertical limit of deviation, so we could be saying 69 metres high. And in terms of the River Dee crossing, it will look awful because there will be 2 pylon lines, one of them already upgraded to 400 kV, and then this new proposal with massive towers within metres of it. So the River Dee crossing will look terrible. And as my colleague has already described, tourism is a really important aspect of our area, and Royal Deeside is internationally famous for its scenic beauty. So to put an abomination like this across the River Dee really just feels completely and utterly wrong. In terms of the height of the pylons, as I mentioned, the ones crossing the River Dee are around 60 metres. If we take the change in elevation between the river and the north side of the valley, it is 50 metres. So by putting these huge pylons at the River Dee crossing, they will tower above the north side of the valley. That's going to totally destroy any sense of being in a valley. The towers will be projecting above the skyline from wherever you go. And then the other thing about the visual impact is because we live in a valley, people walk, they cycle, they bike all over the place. We're often at an elevated position looking down into the valley. So no amount of screening is going to hide these pylons from people who are using the valley for recreation, because they will be at a higher elevation than the river, and they will be looking straight into the pylons, because, as I've already said, the pylons will be taller than the valley is high on the north side. And I just want to reinforce my colleague's question about alternative technologies. We've heard from Mr. Grant that they were ruled out at a very, very early stage. The proposal that was put forward to the community was simply one of overhead lines, and this is it. So in spite of all the input from all the communities about the sensitivity of this area, no other technology has been considered, to our knowledge. Anyway. Thank you.
Okay, thank you. And again, from the applicant's point of view, having heard what you've heard today, but also there's the hearing statement, is there anything you wanted to say by way of response?
Nothing in addition, sir.
Sorry, it was just to add, there is in Chapter 4 a section 4.6.21 which does cover some of the alternatives considered when crossing the Dee Valley.
I'm sorry, you put your hand up earlier and I forgot, I'm sorry.
Hi, in support of my colleague Anne has just stated, regarding the Durris Forest, which lies just south of the River Dee, as you know, we have an existing pylon going from the Dee across to the middle of Durris Forest, which I believe has a corridor of some 90 metres, which I think has recently been widened. We now have the new pylon line being proposed, which again will dissect Durris Forest in parallel with the existing line. Perhaps the applicant could clarify what the new corridor width would be in addition to the existing width, and maybe an estimate of just how many trees are going to be removed from Durris Forest to accommodate these two lines. The second question I was going to ask is, Anne mentioned the moving of existing pylons around Wester Durris, Curtin of Durris. Why are these pylons being moved to make way for the new line, which of course will double the amount of construction activity in the Durris area?
So the operational corridor for the proposed development will be intended to be 90 metres as well. So that's usually for the voltage rather than the size of the tower. So 400 kV voltages would require 90 metre operational corridor, so that would match what will be in place for the upgraded line. In terms of why the existing line is to be diverted, it's to create space between the existing line and the existing properties to fit both of the overhead lines past those properties and have sufficient space, so we're actually moving the existing infrastructure and the proposed development will both be further away from those properties than the existing overhead line is to those properties at the moment.
And have you estimated the the number of trees likely to be removed from Durris Forest to accommodate this new corridor?
I don't have those figures to hand, but the areas will be shown in the EIA.
Okay, thank you. So the next, yeah.
Miss June Morrison from Kintore Community Council is here. She hasn't put a paper into this session, but she has something to add, I understand, to what's been said by her colleagues on my left. Is that correct?
Yeah, that's the line.
Well, I don't know if it's allowed or not, but I think she would like to contribute.
We weren't made aware that
Yeah, no, that's fine. We've got hearing statements, but if you want to contribute then from the Community Council's behalf, then that's okay. Do you want to even get a seat for you rather than... Yeah.
Sorry, we weren't made aware that we had to put in a thing beforehand, so that's our mistake, so sorry. But Lay Lodge is highly impacted by this. Visually, noise, everything. How are you going to be able to hide the pylons in Lay Lodge with any hedges or trees or anything else? Because already the ground round about Lay Lodge is totally saturated by different things. So this is not going to make any difference to us with how you're going to be able to mitigate the landscape, because we are going to be totally indebted with everything in the area. I mean, there's 9 projects on the go just now, with a 10th one on its way. So we add all that into space of half a mile. It is major works there. It's already looking like a bomb site, as I'm sure most people around the table will have seen. We have already asked SSEN to tidy up around the substation, which we think is an absolute red up, and we're still waiting for works to be done on that. People are still waiting for works to be done round about the substation that is now nearly complete, and we're still waiting for bunding and things like that to be done. So when were they considering doing any landscape when it's far too late again? Because everything seems to come at a later stage with SSEN, and we don't actually have the voice, because we say we're things to SSEN on a daily basis. And let me know, I do have a daily basis conversation with SSEN on a lot of things. I mean, I've got emails to prove on a daily basis with SSEN, but nothing ever gets addressed. You know, we've got pylons going over a proposed hydrogen plant. And we were told by Mr. Grant that this was all going to be seen and dealt with, and you would move your plans across, if I'm right or wrong. And it never came.
So I will ask SSEN to respond, only though...
Yeah, that's fine.
Only though about this project rather than about what's happening at Kintore with the existing substation.
This is part of it.
Right, okay, well, but the bunds you talked about from previous works, I just want to...
Yeah, but it's just to give you the indication of how it's going to affect us, because it is still ongoing regardless.
That's fine. I just want to check though, because I'm concerned if you didn't get our communication. We wrote to all the parties and set out very clearly the dates for submission of hearing statements and so on. Did you, did the Community Council not get those?
Nope.
Okay. Sorry, we can look into that when we go back to the office as to why you might not have got that. But I don't know if the applicants get any response to what they just heard there.
I've spoken to Ms Morrison on a number of occasions. I'm not quite sure what you're referring to in this instance, but I'm happy to discuss it after this.
Yeah, I'll discuss it again.
Can we not discuss it in public?
I mean, that was the thing. It was discussed in public, and then I was taken to another meeting, which was then hidden in the background. And I'm sure Miss Wessel agree with us on this one, but we've had various meetings on this one subject, and it is a very important subject, because with the amount of infrastructure going in us, surely to goodness the height and the amount of pylons going in is going to disrupt numerous things in the area, but going right beside a hydrogen plant which has already got the planning permission and nothing has been changed.
To see this thing about the hydrogen plant, are we talking about an existing consent and the Kintore to Tealing power line, or are we talking about, I'd have to check the details.
Yeah, it's all in the one thing.
So have we got evidence about that the cumulative effects with that project, or is it maybe not if it's already consented? But I don't know what the position is.
I think Ms Morrison is more referring to the potential interaction between the two developments. From a technical perspective, we're not in control of developing Kintore hydrogen. It has been in development throughout the same period of time as TCAP has been. We are not the developer in that scenario. The Kintore hydrogen proposal requires TCAP as enabling works to connect to the grid. So in theory, TCAP is required to connect or to be developed ahead of Kintore hydrogen. I'm not quite sure what the understanding is of what I've committed to sort. We're not the developer, and we've got limited control as to what they can progress as a development.
It was to do with the amount of pylons going right beside the hydrogen plant that was my biggest worry. And I've got the plans on my phone to show, if need be.
Can I just, it's probably something we'll have to go away and have a look and see what the evidence is. Is the hydrogen plant consented yet?
I believe, well.
Thank you, sir. The hydrogen plant has planning permission in principle, and there has been no further movement on that.
Okay, so that's helpful. It's something we just have to have another look at and go back. Thank you. Okay, if we can turn now to the effects in the Dee Valley Special Landscape Area. From our point of view, I've heard from the two community councils. I've asked my questions, so I didn't have anything else I was going to go back to parties on. Did you have anything else to add in terms of the Special Landscape Area?
No, thank you.
Okay, I think it's probably a good time to have our afternoon break. So if we I think we're making good time, so let's say start back at 3:25, please, everyone. Thank you. We'll be going to the effects at Lochhoff Park, which I know is relevant to the same two community councils. Yeah, and then after that, I think it's simply the evidence from Mrs. Reid, and then that's the last two subjects. Everyone, that's 3:25, so let's make a start again. We've just got 2 more agenda items to cover off. The last one in number 6 in the agenda was the effects at Lochif Park. So we just wanted to understand a little bit more about what people are interested in terms of the effects there. So I'm just going to read out a paragraph from Carthage, Dromoke and Durras Community Council's statement, and then I'm going to ask you about it. So it says, in talking about Lochif Park, the piling is proposed to run right along the side of Lochif Park, a few metres away from it, not a few hundred, but actually in the boundary of the area. It would totally destroy the visual qualities of the area, affecting areas of peat and the very plant growth that Lochif Park is renowned for. So I just want to make, we just want to be clear, when you say the Lochif Park area, and I've got the Ordnance Survey map in front of me here, I just want to make sure we understand what extent of area that you're talking about when you say Lochif Park. Is it the area that is the SSSI as a kind of proxy for that, or is it a wider area?
Yes, we're referring to the SSSI, yeah.
Okay, and then thinking about today, we're just talking about landscape and visual effects rather than why it might be designated as a SSSI, for example. I was interested in what you see as special about it, but what I was going to do is, there's a paragraph from Aberdeenshire Council's consultation response that talks about Lochif Park, and I was going to read that out, and if you agree with it, you can tell me, or if it misses anything out, rather than ask you to kind of spell it all out. So this is what's in the consultation response. It says, the Lochif Park area close to the Dee Valley is a small-scale and richly diverse landscape, which would be particularly severely affected by the proposed transmission line. The intimate character of rolling landform, woodlands and wetlands, and dispersed buildings would be dominated by the towers, with significant adverse effects arising on its character and on views from minor roads and residential properties. Although this is a relatively little frequented area, the proposed development would form a dominant feature locally in views when seen in the context of this diverse and small-scale landscape. So does that about sum it up, or is there anything you would add to that?
I think that's entirely in line with our view. I think we would maybe just add that it is a nationally important mix of wetland flora, and which has led to its designation as a SSSI. So any disturbance in water levels would have a devastating impact, including the historic King's Well, which is in the area, and that's associated with Robert the Bruce. So, you know, we are very concerned about SSEN's proposal to build massive tower foundations and access tracks in an area where the water level is really, really sensitive. I think we'd also point out that SSEN's ornithological and ecological surveys did not cover this area, and there's Schedule 1A species in the area.
Okay, I mean, we've got that evidence more widely. Again, I just want to focus on the landscape and visual effects today, but that's fine. And on those landscape and visual effects, what we have is viewpoint 31, I think, which is from Cooper's Road, kind of looking north on the edge of Lochif Park, but it does show a relatively small-scale landscape. So, is that, I don't know if you can recall what it looks like, but that seemed to be representative of the kind of descriptor that I just read out. I don't know if Ms Anderson's here. She's not. She made that consultation response. But 31 seemed to us to be a kind of representative viewpoint showing the effects in Lochif Park. Does that seem fair?
I'm not entirely familiar with it. I'm sorry, just the volume of information.
No, that's fine.
31.
Is that figure 935A?
It's it's visualisation. It's number. I think it's visualisation number 31. I can't remember what the exact. But it's a photo montage looking from Cooper's Road northwards towards Lockwood Cottage, and Locker Park's off to the left in the view.
So that's correct. It's viewpoint 31 and it's figure 9.35.
So maybe I'll come back to you, Ms West, but from your, maybe I should ask you the same question then, Ms McGree, that if we're thinking about effects on Locker Park from a landscape and visual point of view, that's our representative viewpoint. That's what we should go to.
Yes, I think that's a good location to visit. It's on the Cooper's Road. It's just at the brow of a hill, and you can pull over at that point and have a good look at the landscape from there.
Yeah, we've been a couple of times there already, actually. Yeah. Ms West, did you want to say something about that?
Yeah, I just want to say that the resident of Lochwood unfortunately couldn't be here today. He is the expert on Locher Park. However, I do know a little bit. I don't know if you remember, I mentioned it in my, the traffic and road statement that Alice Foster wrote out on my behalf. I did mention a little bit about it then, and I think the environmental sensitivity of the Locher Park has been somewhat downplayed. And we have to remember that the nearest Aberdeenshire local nature conservation site with groundwater springs and designated wetland is only 40 metres from the same location. And the risk of hydrological disturbance and sediment runoff, pollution incidents and root damage from the heavy plant construction is really unacceptable.
Okay, that's fine. At the risk of sounding like a broken record, though, I'm only thinking about landscape and visual effects today, not those kind of effects. Okay, that's fine. We've been at that location already. I think now that you've told me it's the SSSI, that will just help us think about where you're coming from in terms of those effects. I think that's all I was going to ask in terms of effects on Locher Park, unless there's any other points you want to make.
There were a couple of questions for SSCN, if that's possible. The first one was, why is Locher Park considered capable of accommodating infrastructure of this scale?
Is that from a landscape and visual point of view? I mean,
yeah, I'd like us only to focus on those issues today. Yeah.
I mean, it is a small-scale landscape, and we recognise that there will be significant impacts in that area. The routing is obviously constrained by a number of factors in that area, and Henry may want to say more about that. But certainly, from a landscape visual perspective, the options that we were looking at were this option that impacts on the Locher Park area, or the option that ran quite close to Drumoak. So it was really a question of balancing between the effects on the population at Drumoak or this more sensitive landscape, but as the Aberdeenshire Council response says, potentially less frequented.
We have another question, please, and that's, how has the landscape character been weighed against the engineering requirements?
So I could, just to go back to the sort of point that Paul referred to in terms of routing, and previously mentioned the two main options that were considered in terms of the crossing of the River Dee and then heading northwards to the terminal point of the project. The routing methodology, the appraisals that were undertaken considered a range of criteria for the environment and technical engineering ones, and additionally cost to some extent. The environmental appraisal, as I mentioned previously, covers a range of factors, including landscape character, visual amenity, ecological effects, other land use effects, including proximity to property. So, as Paul mentioned, there's a number of competing constraints in any route that you're working in. The selection of the option that was taken forward here was on balance across environmental and technical constraints. So it's a blend essentially.
So just following on from that, specifically for the Loch of Park area, what less damaging alternatives were considered?
Would you like me to respond to that?
Yeah, if you're able to, please, yeah.
I'll try to. There were essentially two alternatives considered in this area, both at the routing stage and then at the alignment stage. As I described earlier, that involved a crossing originally further downstream to the east of Drumoak, and the crossing that we've been discussing most recently today in the Loch of Park, Kirkton of Durris area. So the alternatives were set out in an appraisal. The alignment alternatives were considered. On balance, the preference that formed the preferred alignment that we're discussing today was taken forward, partly, as Paul mentioned, in relation to avoiding the proximity to the dense settlement at Drumoak, and reflecting that there were significant constraints on both alignments. On balance, the more westerly option is the one that was taken forward.
Okay, thank you. I wasn't sure whether there was other general points you wanted to make as well.
It was just one last question, that all we've talked about is the alternative overhead line alignments. What about other technologies? Were they ever considered?
I mean, I think there was an answer to that question already in a more general sense, that it was in the EIA covers that area. But I don't know if there's anything particular you wanted to add to that. I've noted down what was said. But
no, just to confirm that there wasn't any alternative assessment for this particular area on technologies.
Okay, was there anything else in terms of Loch Park? No. Okay, thank you. Right, that just brings us to the last agenda item, which is section 7, Lawrence Kirk to Hurley. Mrs. Reid, you spoke earlier about that. Again, we've got your evidence and all the documents. I don't have any specific questions to ask you, but if you wanted to add to what you've put in that, then this is your opportunity to do so.
Just one last question. Could a subsea cable be considered so we can live in peace again?
You've answered the point about alternatives, but I mean that's a more specific question about subsea cables. I don't know if there's a response that you'd be able to give to that.
It's set out in the EIA how onshore and offshore alternatives were considered at a strategic stage. And that's in chapter 4.
Okay, I suppose it's probably worth making the point that the application before us is the application before us, rather than an alternative. Mrs. Reid, did you have anything? You read some of your statement earlier on, but are you content with that, or did you want to make any? Did you want to add to that? Are you okay? Right. Okay. Thank you. Right. That is all the questions we had today. I don't think you get any more. Okay. So before I just close the meeting and just explain what's happening tomorrow, are there any questions outstanding from today, Mr. Wade?
Yeah, sorry to keep bothering you. I always seem to jump in when you want to move to something else. I wonder if it would be possible through yourselves to ask the applicants 3 questions, and if I could read the 3 questions at the same time, so they can, because they flow together, if that would make sense. Is that permissible?
Well, I'll take a view on that when I hear the questions.
Well, stop me if you heard it before. Basically, it's a landscape issue, because I want to talk about, as I've done earlier, the difference between the size of the existing L8 series pylons that are already crossing the Mearns and Deeside, and the monster pylons that are proposed. And the obvious question, which I've not heard asked, and I definitely haven't found an answer, is those L8 pylons have already been upgraded to 400 kV. They're not in operation at 400 kV yet, but they've been reconducted in double circuit, triple bundle setup for upgrading to 400 kV. So the obvious question is, if it's feasible for those smaller pylons to be used for that purpose, why do we have to have much bigger ones? And the second question is, if the new pylons are required for safety reasons, for example, EMF exposure or agricultural equipment clearance, are the smaller L8 pylons that have just been upgraded safe? You can't have it both ways. And if the smaller L8 series are suitable for 400 kV use, why has the existing Tealing to Kintore route not simply been upgraded with those smaller pylons? That was the ASTI determination and the HND FUE. That was the plan all along, to upgrade the existing Tealing to Kintore line, not a whole new line. So, you know, the fundamental question, I think, which is really, as I say, fundamental to the size of the pylons, is a landscape issue, is why do they have to be so big?
Okay. Why do they have to be so big?
I'll go through that in the order in which they were asked. So, Mr. Wade is correct that the upgraded lines are of an L8 type. They are restricted by to what we can upgrade them in terms of capacity to by the fact they're already in situ. There are parts we can do to strengthen towers.
Can you speak up? Can't hear you.
We can strengthen towers, we can strengthen foundations, but there is a limit to the capacity that we can put on those towers. They have been reconductored with the largest conductors that are broadly within the technical limits of what we can fit in those towers. And that capacity results in a conductor capacity in the region of something between around 1200 MVA. That's how we measure electrical capacity. That has, and within clearances that we need to consider for that is the statutory minimum for 400 kV, and also the industry guidance around EMF emissions or you know, well, emissions is probably the most appropriate word. There are 2 elements to those emissions. One is electric field and one is magnetic field. One is driven by current, and so one is driven by voltage. And within, generally, I can't remember which one it is, for that capacity of line, which has a corresponding current, will have a certain EMF level that sits below the statutory minimum, and therefore we can design to the statutory minimum. The new tower suite that we're discussing today is carrying a much higher capacity. Again, don't quote me on this, something in the region of 2,000 to 2,500 MVA per circuit. So that necessitates that the conductors are inherently larger to carry more capacity, and therefore will be heavier. So the towers need to be slightly bulkier as a result of that as well. The other point is because they're carrying more capacity, whichever it is the voltage of the current, whichever infers the minimum clearance, then exceeds the statutory minimum, and that's why we are needing to achieve a higher clearance for those towers designed, which means the whole tower needs to be slightly taller. The reason why we have not been able to upgrade the existing tower line is it's actually of an L3 design, which is no longer in use for new build construction in our licence area, probably across all the UK TOs, because it is too small in terms of the safety clearance to operate. And as a result of that, therefore, it already inherently has a lower clearance to ground. We would likely not be able to achieve the clearance of minimum 9 metres on those towers because they're simply not tall enough. And the towers themselves are probably not also strong enough to carry to carry the weight of the conductors that would be required to manage that capacity that we would need to add on to it. And then you have the inherent issue with the fact that the towers are too narrow, that they can't be maintained safely.
Okay, thank you. I mean, today's session is about landscape and visual effects, but that was a helpful explanation, actually. Thank you. Are there any other points that need to be made in terms of landscape and visual effects today? No? Okay, well that's us finished for today then. We'll aim to start at 9:30 tomorrow. But again, just to say thank you very much to everyone who's participated today. We're back in this room again tomorrow morning. We unfortunately have to, I think there's a judo club in the hall tonight, so we have to pack everything up. But we'll get everything set up again in time for a 9:30 start again tomorrow morning. Thanks very much, everyone. Okay.